22 through 26 that will be discussed at a special meeting of the Land Use and Sustainability Committee next Tuesday, March 5th, 2024.
Members, any additional withdrawal, deferrals, changes to today's agenda? My intent is to follow the agenda, the priority items, and the regular items as printed in the memo I have circulated. With that, is there a motion to set the agenda?
I'll second.
The agenda has been moved and second. All those in favor?
Aye.
All right, with that, Mr. Director, please introduce item number 1.
Okay, item number 1 is to discuss efforts the city can take to recruit qualified architects and landscape architects for appointment to the city's land use boards, including the Board of Adjustment, Design Review Board, Historic Preservation Board, and Planning Board.
Madam Vice Chair, you're recognized to present your item.
Yeah, it's a pretty simple item. Well, the issue is pretty simple. I'm not sure how simple the solution is, but basically, our land use boards are critically important to helping us make wise and informed decisions, and so we seek to get a full representation of views and backgrounds that apply to those land use boards or those power boards, and we are having increasingly difficult times recruiting qualified people because we are constrained to architects who are licensed and practicing in the state of Florida, and people who are those folks often have business that would appear before the land use committees. So they don't want to take those positions because it would impact their ability to do business. Moreover, it is largely a word-of-mouth recruitment process. We know that a vacancy is coming up. We put the word out to our network collectively, whether we're staff or electeds or currently serving on one of the land use boards. And so there's a whole universe of people we're not reaching. And so between the qualifications themselves, I mean, why couldn't somebody who just retired and is a registered architect in Maryland but has just moved down here, why couldn't that person be a qualified applicant for one of the positions if he or she were qualified in every other way, just because they didn't practice here in Florida? So I just wanted to bring this item and have a discussion. I think the staff had made some interesting recommendations, and I'll let staff make the presentation. And with that, Tom?
Okay. As we indicated in the memo, our land use boards have different requirements for architects and landscape architects. On our design review board, there's a minimum of 1 architect and 1 landscape architect registered in the state of Florida. Now, on the historic preservation board, there's a minimum of 1 architect registered in the state of Florida. And the Board of Adjustment, there is a minimum of 1 architect registered in the state of Florida. As Commissioner Bond indicated, these tend to be the more challenging positions to fill because of the fact that you have to have a Florida registration. And as indicated in the memo, as part of our ethics ordinance, it's difficult to find qualified candidates who don't oftentimes have a work conflict. On the planning board, while there is a requirement in one of the categories for an architect or landscape architect registered in the state of Florida, within that same membership category, there's an option for a member of the faculty of the School of Architecture or a professional practicing in the field of architectural, urban design, or urban planning. And so the planning board has a little bit more flexibility. Some of the things that we have come up with in terms of being able to recruit more individuals include enhanced outreach, and this could be things such as posting vacancies on a more visible location on the city's website, sending a notice through the city's email notification service, posting the city's social media platforms such as Facebook and X, further engaging civics groups such as local chapters of the AIA and the ASLA, as well as other applicable arts and cultural organizations and even the Miami Beach Chamber of Commerce, and further engaging universities that have architecture and landscape architecture programs. Some other potential options would be incentives for members, which could potentially be helpful, and these could include things like discounted memberships to city cultural and recreational facilities, as well as discounted admissions to city-sponsored events.
Thank you, Mr. Director. Members, are there any discussions from members on the committee on the item? Commissioner Dominguez, you're recognized.
Thank you, Mr. Chair. I am in agreement with this. I had something similar happen with the Human Rights Committee and the attorneys. This makes sense, and I'm happy to move the item.
I'll second it if there are no further comments.
And for purposes of clarification, the motion is to adopt the recommendations from the planning department.
Yeah,
So the item has been properly moved and second. Is there further discussion on this item? I see Commissioner Rosen Gonzalez is joining us as well. Welcome, Commissioner. With that, Mr. Attorney, let's call the roll.
Before you call the roll, just for clarification purposes, when we send this back to the commission, do you want it sent back with these recommendations in the form of a report, or do you want it as part of a consent reso, or?
Madam Vice Chair, do you want there to be an actual piece of legislation tied for purposes of efficiency tied with this action?
well, Tom, would we need to codify, well, actually, I don't know what the right procedure is on this, so forgive me if I get it wrong. Is there a way to also, in addition to supporting what's here, also incorporate the latitude that is written into the planning board?
Yes.
Structure
If you
into
were-
the others?
Yeah, if you were going to, for instance, incorporate just what has been suggested in the memo, I think you could probably do that by resolution so that the full commission gives the administration the direction to do, say, the enhanced outreach and to look at the incentives. To the extent that you would like to modify the LDRs to provide more latitude within the different membership categories, that would require an LDR amendment, and that would require a
Okay.
referral to the planning board.
So then, with your permission, I'd like to move this forward as a consent item as it is, and then also, and I don't know what the right process for this is, but also recommend that we adopt the broader language governing the planning board to the other land use boards in order to try to address this issue from another way as well.
Mr. Attorney, are we procedurally in proper order with that?
Yes, Mr. Chairman, and we could work with Commissioner Bott on a separate referral to the planning board.
Okay, perfect.
So the item has been moved and second. Are there any members of the public wishing to speak on this item? Seeing no members in person and no members via Zoom with their hands raised, Mr. Attorney, let's call the roll on the item.
Okay, Commissioner Dominguez?
Yes.
Commissioner Suarez? Yes. Vice Chair Bott?
Yes.
Chairman Fernandez?
Yes.
The motion passes.
Mr. Director, let's introduce item number 2.
Okay, item 2 is to consider whether to prohibit existing watercraft rental establishments in the WD1 Waterway District, subject to an amortization schedule.
Okay, and I didn't do this with the prior item, but the attorney has advised me that the proper Robert's Rule procedures for the item to be moved and second, so it can properly appear before the committee. So is there a motion to hear the item?
I'll make that motion.
Second by the chair, the item is properly before us. Commissioner Suarez, this is your item. Please present your item.
Thank you for recognizing me, Mr. Chairman. So I think we have all seen the proliferation of out of touch, out of control charters along the Indian Creek waterway. And one thing that is missing from the Indian Creek waterway is any real infrastructure for a marina. And unlike Miami Beach Marina, there's a dock master, there's showers, there's bathrooms, there's even laundry machines for the operation. And along Indian Creek waterway, there is none. And so I think we have come to a time where it has gotten out of scale for a residential waterway. And I think we need to move forward on protecting that waterway as far as quality of life issues. And so one of the things that I brought up in my recent newsletter is that the reason the bridge at 63rd Street goes up most of the time is because of these charter boats that go through the bridge. And so if we want to get serious on traffic, and there's only so much things we can do to control traffic, and if we can discourage the bridge from going up every 30 minutes, I think that's something that we should take on. So I'd love to hear from my colleagues on what they think about this.
Commissioner Suarez, let me recognize the planning director. Of
course.
Just to go through the recommendations from the city administration and the city attorney on this item.
Okay, Nick, I'll go ahead and start off and just feel free to jump in. One of the things that we had looked at when we discussed this with the city attorney was how best to effectuate an amortization schedule if the commission wants to move forward with this. And what an amortization schedule is basically the elimination of the use over a period of time, so a particular use has enough time to recoup any potential economic losses. And as part of an amortization schedule, one of the things that we recommended if this should move forward is that the city conduct an economic analysis so that we can better determine what the potential economic impact would be through the change of that regulation over time. And then at that point, I think we could probably come up with a more thoughtful amortization period.
Thank you, Mr. Director. And Commissioner Suarez, I wanna commend you because I know you're also working on an LDR amendment that would prohibit new watercraft rental establishments in this area of our city, which I think not only is going to assist with the traffic situations that we're dealing with there, but hearing from residents from that corridor, the noise and the impacts to the quality of life of our residents in this part of the city is real. Colleagues, is there any debate, questions, comments from the body?
I have a question, I guess, directed toward the legal team, represented by Nick. You know, in much the same way that we don't like going about undoing contracts because it's a bad precedent, I share this goal to manage this issue. And so my question is, I understand that there will be legal challenges most likely, but in terms of setting precedent of, you know, if we undo one type of currently legal business, is there, you know, how do we manage that?
Sure, I'm happy to answer that. So obviously the commission takes up, each individual piece of legislation on its own, and just because you look at this particular issue in the context of amortization doesn't mean you have to approach other non-conforming uses in the context of amortization. There is a separate companion item, which the chairman referenced, that Commissioner Suarez has sponsored, which would prohibit any new watercraft rental establishments in the WD1 district, and would also clarify what it means for those establishments to be associated with a hotel. That is going to the planning board tomorrow, and if the planning board makes a favorable recommendation on that ordinance, then zoning in progress will take effect and it'll apply to any new applications. This item would go a step further and amortize any existing establishments over a specific period of time. Any legislation of this nature, which essentially sunsets a legal nonconforming use, is going to be subject to challenge. And our recommendation to you is to do it on an amortization schedule to mitigate the city's exposure to claims. So if this is something you want to pursue, that's how we've structured it.
Okay, and the follow-up.
Through the chair, Commissioner
sorry.
Vada, and then Commissioner Suarez.
Sorry, thank you. Just to follow up on that, then also, we don't want unintended consequences of cleaning out this corridor, which is important, and then, you know, what happens to those businesses that then try to find another, no pun intended, safe harbor to do what they do, whether it's legal or not. How do we, what I don't want to do, and what I worry about when we try to make change, which shouldn't stop us, but it is a concern, is that I don't want to kick the problem down to a different piece of our
City.
our waterways into a different neighborhood. So fix this, yes, but fixing this cannot mean by default that it's going to go, you know, down to South Beach or West Avenue or up to North Beach or, you know, any of the little nooks and crannies that have water.
Thank you, Commissioner. Commissioner Suarez, you're recognized.
Thank you. Thank you, Chairman. That's exactly what we plan on doing. And what the idea would be is to move them to a marina that has the infrastructure to handle these operations. Because right now, Indian Creek Waterway, they don't have the infrastructure. They don't have bathrooms. They don't have showers. They don't have a dock master. There's really no one looking at what's going on. They don't even have a gas station there. And so, you know, at Miami Beach Marina, they have all of that. And that's where and that's where an operation should be for charters, not along a residential corridor. You know, a lot of these, and look, as you know, everyone, I've put forward a lot of ordinances to prohibit parking on the swales and noise, but, you know, people are driving on the sidewalks and then pumping gas from these huge gas tanks to fill up the tanks. It's just, it's what Nick said, it's legal non-conforming. It's non-conforming right now for the neighborhood. And so by the way, it only applies to 2 hotels, okay, that are allowed to do any sort of commercial activity as far as charters goes, and that's the Fontainebleau and the Eden Rock. And there's also the Miami Beach Resort, but they're closed, so they're technically not supposed to be doing any charter activities. So, you know, I think as we get into greater discussions on what do we want to see Miami Beach as in the next 10 years, you know, it's going to be an uncomfortable step, but ultimately we want to protect our residential, not only neighborhoods, but our waterways. And I think this is a bold step in that direction.
Through the chair.
Yes.
So I am 100% agreed with you. What I want to avoid, though, is maybe not the Fontainebleau and the Eden Rock, who will probably abide by whatever the rules are and figure out a way to make this work financially. It's the smaller people who do this, because I know up in North Beach, we already have all kinds of illegal or not quite sanctioned or, you know, jerry-rigged businesses that pull up to the gas station that's now closed, but pull up to the gas station when it's open, take their 5-gallon tubs or 5-gallon containers, pour the gas in, literally in the water, and then go off. And so what I don't want is for the folks who are like in between to just, again, not the operators who will do the right thing, kicking and screaming, but everybody else to say, oh, well, they're not going to find us in North Beach, or nobody cares, or, you know, if we want them to go to the marina. We have one marina right now. Does it have capacity? If not, what are we going to do about that? I just want to make sure we don't leave gaps for people to continue doing things we don't want them doing in other parts of the city.
Thank you, Madam Vice Chair. And I think one of the items that could be considered, if this item does move forward to the City Commission, is a capacity analysis in our public marinas of the feasibility to accommodate this in public marinas. And certainly, you know, better enforcement in our residential waterways, because we do know that illegal operations are occurring in our residential waterways. But this is just a further step to clamp this down. To the sponsor, is there a motion that you would like to proffer on this item?
To move the item, right?
To move staff recommendation to move the amortization of existing watercrafts in the W1 district, move that recommendation to the City Commission together with the authorization to retain an outside consultant to conduct an economic analysis?
And that's through the chair. That's through Tom, right? That was the recommendation. Would it have to go to a finance committee, or is it just?
Yeah, it could, the retention of an economic consultant could either be done potentially through a budget amendment for this fiscal year, or if you wanted to make it part of the fiscal '25 budget process, you could do that.
And through the chair, just a question on the amortization piece. So the amortization piece is just a recoup cost of exactly what? Is it the docks itself?
So that's a good question. We think that analysis should at a minimum include the difference between what a property owner, because these are you know, little out parcels along the waterway, what one of those property owners, the difference between you know, what they make from renting it out to individual charter operators versus what they might make renting it out to a, you know, long-term recreational boater who wants to keep their dock there. So we think that that should be part of that analysis, and you know, there may be other factors that should be included, but that at a minimum.
And through the chair, this doesn't necessarily remove the dock, correct? It just removes the business aspect of it. So
That's right.
they could, if they wanted to, they can park or they can dock a private vessel there.
That's right.
All right, let's bring this item for landing. Is there a motion on the table?
I make a motion to move it to the commission and sponsor the research.
Okay, and is there a second on that?
So, through the chair.
Yes, and let's bring this for a
Yeah,
landing.
when you say do the research, meaning the second piece.
Economic analysis.
So can we just combine those? Well, no,
Yeah.
I'm sorry. What I was asking about was the capacity at the marina. Can we combine the capacity at the marina with this so it all gets done at the same time?
That's up to you as to how you want to recommend it. If you want to recommend them together, or if you want to, I think they're separate analyses.
Commissioner Suarez, would you like to include that recommendation as part of the motion back to the city commission?
I just want to be clear on what that is, and I'm trying not to take so much
Yeah.
time. So what exactly would we be looking for to see? Because I know that there's a waiting period at Miami Beach Marina for a slip. However, that doesn't necessarily mean that you can do pickups and drop-offs at Miami Beach Marina, because they do have landing fees. So for example, if you have your boat anywhere else in Miami Beach and you want to pick up at Miami Beach Marina, you pay a landing fee, you pick up the fuel dock, your party, they do it all the time, and then they can leave. So I wouldn't say necessarily that you need to have a slip there to operate. They have rules and regulations on landing fees. So if you have a business, you can run it through Miami Beach Marina as long as you pay a landing fee.
I think it would be good to get an analysis from the administration when this goes back to the city commission with just to know our understanding, just for the benefit of the full body, what is the ability to accommodate these types of uses at the marina, if this item does proceed. Commissioner Bob, would you second the item?
With that amendment, yes, absolutely.
Okay, so the item moved, seconded, as amended. Mr. Attorney, let's call the roll.
Okay, Commissioner Dominguez,
Yes.
Commissioner Suarez,
Yes.
Vice Chair Bott,
Yes.
and Chairman Fernandez.
Yes.
Okay, the motion passes.
Mr. Director, let's introduce item number 3.
Okay, item number 3 is to repeal co-living incentives along Washington Avenue and restrict the maximum number of co-living units in the North Beach Town Center Core District to prohibit the approval of any new co-living development in the city.
All right, with that, is there a motion to hear this item?
I will enthusiastically make that motion.
All right, second by the chair. This is my item, but I'm going to recognize the planning director to introduce it.
Okay, Mr. Chair. As we indicated in the memo, there are 2 areas of the city that currently permit co-living in some capacity. And that is the Washington Avenue corridor, the west side of Washington Avenue, and then the east side of Washington Avenue in a more limited area in the 15 and 1600 block. One project has been approved for the west side of Washington Avenue. However, that project must obtain a full building permit for the co-living units by May 27th of this year. If it does not, those co-living units would not be able to move forward. Similarly, for the project that was proposed on the east side of Washington Avenue, while that project has yet moved forward and received approval from a land use board, there is a deadline for the permitting of that as well. Finally, in the North Beach area, the ordinance that created the TCC district allowed for co-living units but set a cap, and that cap was 550 units. However, all of the co-living units that are contemplated in the North Beach TCC needed to have received a building permit process number no later than October 1 of 2023, which was last year. To date, only 529 units were able to obtain a building permit process number, so only those 529 units are eligible to move forward, assuming their building permit remains active. If any of their building permits should expire, they would lose the rights to those co-living units.
Thank you, Mr. Director. This is an item I placed on the agenda because I do feel that perhaps we've over-legislated the amount of this type of use in our city without truly knowing what its impact will be to the quality of life of our city and to the level of services of our most essential public services. How does this impact noise, sanitation, traffic, public safety, code enforcement, and most importantly, residents' quality of life? 529 of them have already been permitted. In North Beach, we can't take that away at this point, but what we can do is go back and repeal what's been approved previously in the Washington Avenue corridor. With that, I would like to recognize my colleagues. If there's any questions, Madam Vice Chair, followed by Commissioner Suarez.
Yeah, so I'm thrilled that this is a conversation, and I was thrilled to see it be recommended by you, and I enthusiastically co-sponsored this proposal. I know that you've made it clear that the 21 remaining sort of orphaned co-living units in North Beach can't come back, but, you know, Dawn of the Dead and all those zombie movies, I see these 21 little co-living spots coming with their little hands out of the grave with some cute little building that looks like we can just make an exception. Can we just, to tie this off, get rid of those as well?
Well,
Can we make that-
they technically are gone.
But can we
because
just say that in black and white?
Under the code, it already says that, because they didn't receive a building permit. So in the LDRs, it says very clearly, in the TCC district, all co-living units must receive a building permit process number by October 1 of 2023.
I hear you, but I just see some enterprising young land use attorney coming in and trying to make a case saying, well, there were 21, so just give it to us.
I mean, we could amend the LDRs to basically remove that language and set the cap at 529, but I think it would be important to leave that date in there. And the reason is that if any of the other building permits should expire, then that date prohibits them from renewing those.
Oh, I don't want to change the date. I want to keep that in. I just want to put every possible nail into the coffin.
Then, yeah, you could reduce the cap from the current 550 to 529.
Madam Vice Chair, would you like to make a motion on the item?
With the modification proposed, I would like to move this item.
Okay, second, Commissioner Suarez, you're recognized.
I just want to say I'm fully in support of this item, and you know, co-living spaces. So it's over then, right, Tom? It's been removed.
As far as new
Through the
ones,
chair.
yes. And just to clarify the motion, it would be to refer an LDR amendment to the planning board that would, one, repeal the co-living allowance along Washington Avenue.
Correct.
That would remove the ability for anybody to do co-living along Washington Avenue. And then in the North Beach Town Center, it would set the cap at 529. So there would not be able to be any new ones in the town center.
Correct. Correct. So it's been moved, seconded. Is there more debate from
Who was the second?
committee?
I'll second it.
Or Commissioner Suarez? Seeing no debate from the committee, are there members of the public present wishing to speak on this item? I see Mr. Wayne Roberts has his hand up on Zoom. Mr. Roberts, please state your name for the record. You have 2 minutes to speak.
Alex, you know who I am.
I know who you are.
So I'm Wayne Roberts. I live south of Fifth. I congratulate you on reviewing the decisions of the past and modifying them to try to mitigate a lot of the damage that it would create. North Beach is being inundated with development that I don't think is powerful or beneficial. A lot of it is, a lot of it isn't, and this is one example where I think it's been overextended already at 529. I would ask you to consider, because of Washington Avenue being, it's somewhat hurting. So maybe 50 or 75 units to test the waters on Washington Avenue, 50 units, whereas with the 6-month minimum time frame for residency, so that we could test the waters on Washington Avenue without like fully shutting it down. 50 units won't matter much, but we could see what it does to Washington Avenue. Thank you.
Thank you, Mr. Roberts. Are there any members of the public? I see Commissioner Magazine has his hand raised. Commissioner Magazine, welcome. You're recognized.
Probably in the gym.
Thank you all for the discussion. This is certainly something I am fully aligned in agreement with. Never a fan of these co-living quasi short-term rental units. Understand that this is somewhat bifurcated, where we're trying to mitigate the damage that's been done that hasn't moved forward yet. I would just ask if there would be any appetite to consider where the co-living units that have already been approved, if there's the ability, perhaps we send this back to the planning department, if there would be the ability to provide some sort of other incentive to get the current property owners or developers to look at uses that we feel are more in line with the city that we would like to see. Full-time residential housing that is actually accommodative for young professionals, young families, working professionals, and things like that. But thank you for the discussion, and to the chair, thank you for allowing me the comments and your diligence on this matter.
Thank you, Commissioner. It's a pleasure to have you participate. I hope you're able to join us for the remainder of the meeting. To the planning director, I think Commissioner Magazine has raised an interesting point and perhaps something that might be worthy of consideration with those 500, if I understand correctly, what he's suggesting is 529 units that have been permitted in North Beach. Perhaps all of them haven't been built out yet. A discussion of what incentives could the city offer to try to convert these units from co-living units to some other type of unit that might be necessary or needed in the market. Madam Vice Chair, you're recognized.
Yeah, thank you. If there is the ability to at least go back and review what could be done, I would be super supportive of that. If you need a sponsor as a separate item, count me in as that sponsor.
It might be a good idea to perhaps refer that as a separate item, because that would be coming up with incentives for converting either existing approved and permitted, or those that have just received the permit process number but have not gotten off the ground yet, back to full-time residential or regular long-term residential.
Let's perhaps, Mr. Director, work on a referral for the March meeting to refer this item, as stated by Commissioner Magazine, to this board and perhaps also to the planning board. It might be helpful to get input from them. I'm happy to join as a co-sponsor. I think we just heard from the vice chair, who's happy to join Commissioner Magazine as a co-sponsor of that item. We have a motion before us on the table. It's been moved and seconded. Mr. Attorney, let's call the roll.
Commissioner Dominguez,
Yes.
Commissioner Suarez,
Yes.
Vice Chair Bott,
Yes.
and Chairman Fernandez.
Yes.
The motion passes.
With the setting of the agenda, I said that I was going to follow the order of the priority and regular items on the agenda, but my dear friend, Commissioner Rosen Gonzalez, is here for one of our items, and she is my friend. Mr. Director, let's call up item number 7. Let's introduce item number 7. Just let's allow the director to read it into the record.
Okay. Item number 7 is to discuss the use of color in Art Deco architecture, including the color palette developed by Leonard Horowitz. Discuss how to encourage property owners to incorporate color in exterior paint for Art Deco buildings, and identify a city building that could be painted in a manner that highlights its architectural features, for example, by using the Leonard Horowitz color palette.
Thank you, Mr. Director. To bring the item properly before us, is there a motion and a second?
I'll make the motion.
Moved second. Commissioner Rosen Gonzalez, you're recognized.
Thank you. We have somebody very special here in the audience today who I'm hoping will come forward to the podium for a presentation, Ms. Hulaniki. We have an iconic interior design, fashion, yes, internationally renowned designer, Barbara Hulaniki, here today. For those of you who don't know, in the 60s and 70s, Barbara Hulaniki, her brand was in London. It's called Biba. It was internationally renowned. The podium is right there, and Amber, give Ms. Hulaniki. And when we started South Beach in the 80s, Craig Robbins and Chris Blackwell of Island Outpost and the Estefans, who were doing the Cardozo, reached out to Barbara Hulaniki, who actually lives in South Beach. So when she was being honored by all of these iconic people, Chris Blackwell flew in, okay, from London or Jamaica or wherever he was to honor you, and so did Craig Robbins and the Estefans, and everybody was there, and everybody believes in you, loves your fashion icon. She came up to me at this ceremony and said, you know, I've got an idea for South Beach. I said, what? We don't really have any money. She said, this idea is not going to cost you a lot of money, but it is going to inject a lot of life and a lot of vigor and a lot of creativity, and it's going to be somewhat of a renaissance. So, Ms. Hulaniki, would you like to embellish upon your idea for rekindling, renaissance, something to really create some wonderful press in South Beach and highlight our Art Deco architecture?
Welcome, Ms. Hulaniki. You're recognized.
my husband and I discovered Miami Beach in 1960 something, where we started coming here because it was a direct flight from London. And there were all these little fabulous little buildings like little cakes, and all these people sort of swimming around, and there wasn't that much colour at that time, but it was just the energy there was absolutely incredible. And there was, we settled here because I started working for Chris Blackwell and Ronnie Wood, one of the Rolling Stones, and you sort of got into the whole vibe of the place. And what was really interesting is that there was Leonard Horowitz, who by the time we got there, I think he wasn't with us anymore, but I just fell madly in love with his colours, which were absolutely incredible. And I then, when I started working for Chris, I wanted to find out about why these colours weren't being used. And it was because the paint people hadn't discovered how to, they couldn't hold the colour, it just became even lighter, so everything became completely whitish. And of course now they've solved all those problems. And he was the most incredible colorist I have ever met. I mean, he was incredible. And it'd be so wonderful to do something wonderful for him. But with his colorways, it's very important that this whole scheme is comfortable together. Because I had certain clients who would come to me and said, I want colors, Jamaican colors. Bah. And, it was, this would be a law of, like, let's do Horowitz and stay within that. And I mean, there are millions of colors that he uses that you have. And also the paint companies probably would help out very much. And then also working with the canvas people for the umbrellas, which are very important.
So the idea behind the program and what we have here is we were going to pick one city building to start and then really repaint it in popping Art Deco colors. So I believe, do we have someone from the administration who has been working on picking a building, or are we just, Tom? Did
Yeah,
you guys?
I can speak to this briefly. There are a couple of city buildings that we think could qualify in terms of architecture that would be good examples because of their location and their architectural style. One would be the Colony Theater, the other would be the Miami Beach Patrol headquarters. Whether or not there would be any budget implications with regard to that color, I think that's something that we would need to further explore, but those are two city buildings that would come to mind that could potentially accommodate a color scheme like this.
So we were hoping to possibly start out with one or even two buildings. I would direct to repaint two of them in eye-popping colors, but the idea, and Barbara had some great ideas, was to reach out to some sort of, number one, paint company to possibly get a sponsorship so that we don't necessarily have to purchase the paint. And then second, once we do this, it's more about like getting a whole block together and repainting an entire block. And she had another idea, like it could just be like one block is all pink, the next block is all yellow or all green. And it's like to make a statement, to kind of take an area that is a little bit tired, it's a little bit worn. We've seen the sidewalks are full of gum, Commissioner Suarez. No, but we have sidewalks that are a little bit ratty and tatty. So we thought that the painting of these buildings, which is what they did in the 80s, created a huge media surge, international media. So what we were hoping is to first paint these two buildings and work with have the administration work with Miss Hulaniki to pick out the colors, to do something really spectacular. She's volunteering her time, and you should reach out to her, go see her studio on South Beach. It really is an inspiration. It's part of our history and what she's done. So
Thank you, Commissioner Rosa Gonzalez. Do you want to move the administration's suggestion of selecting the Colony Theater and the Beach Patrol Building headquarter for consideration at the City Commission? Would you like to move that so that then we can continue with debate from the dais?
I don't think I can move anything because I'm not
Oh.
on the committee. I'm just here to hear it. And would
That's
that
right,
be,
you're-
Barbara, so that would be the idea? We're gonna pick 2 city buildings to start and work with you on a color palette to repaint those buildings so that they pop. And once we go and we look and we create a ribbon cutting, maybe then we can move to a pilot program where we take an entire block or a couple of blocks and
Yes.
work with the owners
Yeah.
to paint them.
Okay,
Yeah.
so
And by
is
the
there
way,
a
I
motion
think-
from the table? Is there a motion from the table to accept staff's recommendation of the 2 buildings to possibly paint?
I think it's very important to look at the canvas they're already using on the,
Thank you, Ms. Horvath. Thank you. Thank you.
because
So-
that's terribly expensive.
Thank you.
Oh.
Yeah.
Is there a motion on the table?
I'll move it. I have some questions though.
Okay, it's moved by the vice chair, seconded by the chair. Commissioner Body recognized.
So you might notice that I'm a big fan of color. Between the shirt that I'm wearing and my little wrap behind me, color is my dearest friend. So I'm thrilled at this concept. I think it is an inexpensive and really powerful way to send a strong message about who we are, who we've been, and who we want to be going forward. 2 questions. One, have we looped MDPL into this, Miami Design Preservation League?
We have not, but Daniel is aware of it. He said that when we could refer it also to the Historic Preservation Board, also. But we wanted to start with these city buildings, and then when we move forward with the pilot program, and I'll bring, I guess, an additional item then to pick out to do a pilot program. I don't know if you'd like to co-sponsor this because it's going to take some work to pick a block, work with the property owners. But once we do, and create the media buzz that we need to create, working with Ms. Holandiki, because this was her idea to make everything pop. So we could. I don't think I can refer from here.
No, but
All right,
along those lines.
let's keep the conversations through the
Through
chair,
the chair.
please. Yeah.
Along those lines, I would encourage us as we move forward past the initial 2 buildings, or maybe now if it's possible. North Beach has this incredible collection of a handful of Art Deco buildings, but mostly mid-century modern buildings. And while the color palettes are a little bit different and the use of color is definitely different, there is an enormous opportunity up there with a much larger concentration of buildings that could use a little TLC to take the same concept and do the same thing up there. And so I would encourage us as we move forward to do it at both ends of the island.
And thank you, Commissioner Bott. And I wanted to mention that we have the North Beach CRA Facade Improvement Program, that through the CRA, we have dollars that we're issuing grants to private property owners. And perhaps we could use that facade improvement program as an incentive to get some of the beautiful, architecturally significant buildings in North Beach and accentuate them with some of these beautiful colors. And Commissioner Rosa Gonzalez, I want to congratulate you because I don't know how many times I've driven down some of our main corridors, and we have these beautiful buildings, but they're all very monochromatic. They're all just, they're all white or they're all one color, and you don't get to experience the beautiful architectural features to as much as you could otherwise if it actually had colors accentuating them. So, so there was a motion, there was a second. Mr. Attorney, would you like to restate the motion just to make sure we have it in proper order and the administration has everything that is needed in order to get this moving forward?
As I
Just
understood the
add
motion.
something, is to get
Yes.
paint companies involved. One paint company and
Yes.
such advertising for them, wouldn't it? If you got 5 buildings by whatever.
Thank you.
Yeah.
Thank you.
I would make that part of the motion too, to reach out to some paint companies, even locally, to see if they'd like to sponsor, because I think the whole idea behind this is media. I mean, apart from refreshing and making it beautiful, but having some positive, we really want positive media in South Beach. All we get is this negative media again and again, kind of like yesterday they were talking about at Muhammad Ali. Look at how beautiful this
Yes.
exhibit is. Why aren't we focusing on this? So I
So,
would
Mr.
make it-
Attorney, let's state the motion on the record, incorporating the suggestions of working with a paint company, which a wonderful suggestion.
So as I understand the motion, it's to make a favorable recommendation to the City Commission to move forward with painting the Colony Theater and the Beach Patrol headquarters, and work with Ms. Hulaniki on coming up with an appropriate
Color scheme.
color palette.
Yes.
And
And a
and then-
media campaign included with it, and, you know, issue some press releases. I think that's important. And, yeah, and try to find a paint company and work with some media. This is the first step,
Yes.
Barbara, because
So-
it takes a while.
So you got that all, Nick? Because it's a lot of, we also mentioned the North Beach CRA component of it with a facade improvement program where we have dollars that we can actually use to implement something like this. So you've got all of this enumerated in the motion? Yes, okay. Commissioner Rosa Gonzalez, just to close before we call the roll on this.
I just want to say thank you, and I'm really excited about this, and the city's going to be reaching out to you, Barbara, and thank you so much for coming to us with your brilliant idea, and I'm looking forward to see the color scheme that you choose for these two buildings, which will make it even more iconic and even more press-worthy that you're involved in this initiative, and hopefully when we save the South Shore Community Center, we can repaint that too. Thank you.
Who's going to
Thank
pick
you.
the
Thank you so
first
much. Thank you for joining us
And
today, Mr. Yes.
Who was the motion maker in the
The
second?
motion was made by Vice Chair Bott. I seconded
Okay.
the item. Are there any other members of the public present to speak on this item? Seeing none in person, none virtually, Mr. Attorney, let's call the roll on this item.
Commissioner Dominguez?
You're gonna vote for this? He's calling.
Oh, I didn't hear it.
I'm sorry, Commissioner
Yes.
Dominguez? Commissioner Suarez?
Yes.
Vice Chair Bott?
Oh, yes.
And Chairman Fernandez?
Yes.
The motion passes.
All right, with that, we're gonna go back to the order of the agenda. Mr. Director, let's call up item number 4.
Okay, item number 4 is to discuss the proposed Sixth Street overlay.
Okay, and is there a motion to bring the item properly before us?
All motion.
Okay, moved by Commissioner Suarez.
second.
Seconded by the Vice Chair, Commissioner Dominguez. You're the co-sponsor of this item together with Mayor Minor. You're recognized to present your item.
Thank you. So this item has been long in the making with the Flamingo Park Neighborhood Association, and it has to do with the overlay for their particular area. There is a project in question. My understanding is the Flamingo Park Neighborhood Association has said that their variances and their project is approved, can move forward as is, and should the project in the future get demolished and be redone, then it would be part of the overlay. And Mark Needle from the Flamingo Park Neighborhood Association is here to talk about it. And then we also have Michael Larkin, who's here on behalf of the developer.
Thank you, Commissioner Dominguez. Before proceeding with members of the public, I'd like to recognize the Planning Director to speak on the item.
Sure, and Mr. Chair, I'll just give everybody a very brief refresher on this since it's had a fairly lengthy history. This was originally referred to the Land Use Committee in July of 2021, and it spent about a year at the Land Use Committee, a little over a year, and then it was referred to the Planning Board by the full commission. Last September, at the request of the item sponsor, the item was removed from the Planning Board agenda and re-referred to the Land Use Committee to further take a look at the proposed components of the overlay. And as indicated previously and as more detailed, set forth in more detail in the memo, this creates what I would characterize as a transition zone between the north side of Sixth Street, which is zone CPS2, the south side of Sixth Street, which is zone CPS2, and the north side of Sixth Street, which is zoned RM1. They're fairly diverse zoning districts. And while the overlay would apply to the larger area between Fifth and Sixth Street, the regulations that would pertain to those properties much closer to Sixth Street are a little bit more restrictive. I won't go through all of them because they're all detailed in the draft referral ordinance, but they do deal with limitations on alcoholic beverage establishments, particularly on those properties that are within 200 feet of the south side of Sixth Street. They deal with the types of not entertainment, because entertainment is prohibited in the area, but the types of speakers, outdoor music, even an ambient level, and television sets where they can be located. They also have limitations on access points to hotels and commercial uses for properties that front directly onto Sixth Street. And they propose to prohibit certain types of uses within the overlay, including hostels, convenience stores, smoke and vape stores, and package stores. Lastly, it sets forth minimum clear pedestrian path requirements for sidewalks within the overlay, as well as a limitation on the maximum permitted height within the first two platted lots south of Sixth Street, which the administration has recommended not exceed 50 feet in height.
Thank you, Mr. Director. Commissioner Dominguez, you had members of the public you wanted to recognize. I see Mr. Nito is here from the Flamingo Park Neighborhood Association. Welcome.
Thank you.
How much time, more or less, do you feel you will need for your presentation?
If you want me to speak more, I will. Let me just start with a brief overview, and if you would like to go into more detail,
I'm going to give you 3 minutes.
Okay.
Is that good?
That's fine.
Okay, thank you.
So I want to thank you all for the interest you've showed in this issue over time. I think dealt with everyone here at one point or another. Several of you were on the planning board. Several of you were on the commission the first time we came through. And thank you, Commissioner Dominguez, for co-sponsoring along with the mayor. And Commissioner Suarez, you were actually participating in informing this when we were in the conceptual stage. And the concept is really simple. We have Flamingo Park Neighborhood Association. I'm Mark Needle at 910 Lennox. We've done 2 overlays so far, and they've been very successful. One was form-based on the interior, and it stopped incompatible infill development. The second one was on a commercial edge, Alton Road, where there was incompatibilities that needed to be addressed in terms of use and the scaling. And that overlay went into effect, and it's been very successful. If you look at the PowerPoint I shared with at least those of you on this committee, you'll see examples of how it works, and it prevents the exact kind of thing that happened now at 6th Street, which is where we have a very large commercial building that was built with as of right, with no attention to the historic adjacent to it, and it made it kind of incompatible. So now we have approved, I think you were referencing this, Commissioner Dominguez, we have approved grandfathering those projects that we think are incompatible and were wrong and shouldn't have been built the way they are, but we want them to be fully vested for as long as they exist, not affecting their financing at all. But if there is ever a decision to redevelop the block, it should follow what we're proposing, which is really common sense. It's pushing back the massing, it's pushing back the most damaging uses, the most intensive uses, hotel, transient uses, the alcohol, of course. We're really focusing not on mom and pops, we're focusing on large scale redevelopment. And so we urge you to, when we went through the first time, we thought let's just get it out of the committee and then we'll address this at planning board. Ultimately though, we learned that we needed to do it right from the start for the massing and scaling piece, which by the way takes no FAR away from the developers. For that to be considered, it needed to come back to you and start again. And our position is we'd rather get it right than get it fast. So if you want to do more on this, we're amenable to it. We have been willing to work with not only grandfathered projects, but a project that has proposed that for use at Jefferson Avenue, and I can't approve of the language that's in there today because we haven't reviewed it as Flamingo Park Neighborhood Association. But the concept of consensus is what we're all about.
Thank you, Mr. Nito. Are there more members of the public present wishing to speak on this item? You were recognized by the sponsor, so I granted you a little bit more time. I see Mr. Larkin has approached the podium. Welcome, you have 2 minutes to speak.
Thank you, Mr. Chairman, committee members. Michael Larkin, 200 South Biscayne Boulevard, here representing the owner of the property, Russell Galbett. Specifically, it's 1030 6th Street. We're respectfully requesting to have this property be excluded from the scope of the 6th Street overlay. A simple exclusion would be for a property that's located west of Michigan Court, which is the alley that forms our eastern boundary, which has a lot line on 6th Street and on Lenox. We believe it's appropriate to exclude this property. It's at the very western end of this overlay, adjacent to a very large shopping center to the west, church to the northwest, and we feel that it's most compatible with these neighbors, and we don't feel there'll be any harm caused by the exclusion of this property. We don't want to be rendered a legal nonconforming building. It gets harder to get financing when you're a legal nonconforming building and get insurance. So respectfully, we're requesting this exclusion. Thank you all very much for your time.
Thank you, Mr. Larkin. Are there more members of the public present in the chambers wishing to speak on this item? Seeing none, I see Mr. Johan Moore has his hand raised. Johan, you're recognized. Johan, you need
Yes,
to-
good afternoon.
Good afternoon, welcome.
I cede my time to Mark Needle to make further comments.
Johan, we do not yield time, but you're welcome to speak on this item. We already granted him more time than we give other members of the public.
Well, I will just back up everything that he has said, having had the privilege of being involved on the subcommittee that has carried this forward. I want to emphasize that we've really reached out to the neighbors, and we apparently do need to review the final language, but I want to urge that the committee, in fact, base any final decision on the neighborhood association's assent to acceptable language. Thank you very much.
Thank you, Johan, for your participation. Any other members of the public wishing to speak on this item? With that, I'm going to close the public hearing on this item. Commissioner Dominguez, this is your item. Is there a motion you'd like to make on
I
it?
think what I would want to do right now is to defer it for 1 month, and the reason is I thought that everything was neat and ready to go, and it's still not. I heard from the developer multiple times today screaming and not on board. So I would like to set up a meeting outside of this so that the neighborhood association, the developer, their attorneys, and me can all talk this through and move forward.
Thank you, Commissioner Suarez. You're recognized. Well, first, there's a motion for deferral on the table. Is there a second on that motion to defer?
I'll second that.
Okay, the motion is moved to seconded. Commissioner Suarez, you're recognized.
Thank you, Mr. Chair. I wanted to know if we can ask Mr. Needle what his thoughts on possibly excluding the Lenox Avenue address from the overlay.
Mr. Needle. Just to respond on that issue specifically.
We are not in favor of exclusion. We're in favor of grandfathering the project, but our concern is this. In the future, if that project was redeveloped as part of a full block development, it should not have a hotel facing the residents, period. And this is a bid to keep that property out of the overlay, common sense rules forever. We need to address it as a grandfathering issue, and on that, we are happy to take the month and work on coming back in a posture that at least identifies whether there is an issue of grandfathering.
Through the chair, Mark. It seems like you're okay on both sides. Are you okay with this particular project moving forward?
We actually approved. The developer of this project asked for our support and said that he would support our overlay district if we did support it. So we supported variances. They gave increased height for this project. We're not stopping this project. When I say we, I mean Flamingo Park Neighborhood Association. We would expect the same courtesy back, which is what we were told, which is that not to support the ordinance by taking their properties out of it, but by making sure that the grandfathering is appropriate and that the ordinance protects that buffer between height and intensity and residential, even after those uses may change in the future.
Thank you, Mr. Needle. And perhaps one of the matters that could be explored by our legal team between today and the item coming back to the committee is any avenue that could be done for any property owner with a building permit or a land use board order to on applicability or some avenue that could keep them from entering into a non-conforming status But it's something just to explore between now and this item coming back.
If I may,
Yes, Mr.
Mr.
Attorney.
Chairman, I think the options are, if the property has approval, so if this ordinance move forward, the property would become legal nonconforming. The options are either the property becomes legal nonconforming or that area is excluded from the ordinance, but we'll continue to look at it.
Yeah, because I understand the concerns of the neighborhood. They supporting the application that got approved already, something that they feel comfortable with. But as a body, I guess we're always tasked about legislating in the present, thinking about the future, and not knowing what could potentially happen in the future. We do owe it not only to protect what has already been approved, but also protect the quality of life of our residents from unintended consequences that could emerge in the future. So I'd appreciate us looking further into that. I do have a question because I noticed that I understand that the residents wanted everything fronting 6th Street to be limited to 28 feet in height, I believe. Is that accurate? However, our staff was recommending that it shall not exceed 50 feet in height. I just would like some input and feedback from our staff on that, the logic, the thinking in that recommendation.
Sure, we had, this deals primarily with the first couple of lots that front 6th Street that are probably the most sensitive in terms of height. And we certainly think that there is a way to step back the height of buildings on larger aggregated lots. However, if somebody is only developing 1 or 2 lots, we didn't feel it would be appropriate to set a hard cap of 28 feet because we think it might be difficult for a property owner to maximize their development rights, and the city might be subject to a Harris claim. So one of the things that we have discussed is the possibility of the Historic Preservation Board granting a waiver to go up to 50 feet. So if a building did have a height cap of 28 feet, there would be the ability for the Historic Preservation Board to grant a waiver for a property on a case-by-case basis to go up to 50 feet.
Thank you. I wanted to know the rationale for the recommendation, but we had discussed that in my briefing. It was something that I wanted to propose about exploring what we could do to accommodate that. I think it's something that should be discussed with the neighbors to see if it's something that they would be amenable to, because the last thing we would want to do is to pass a good piece of legislation for the quality of life of the neighborhood and the future of the neighborhood, but then only to have it challenged with a Harris claim, and then for the item to be potentially repealed in a legal challenge. So I think since Commissioner Dominguez has done a motion for deferral, I think this is one of those items that we can discuss further between this month and next month. With that, can we approve the deferral by acclamation unless there's further discussion? Yep, okay. Let's show the item deferred. Thank you all for attending and participating on this item. Mr. Director, let's call item number 5.
Okay. Item number 5 is to discuss a proposal to designate the Standard Hotel, former Lido Spa property at 40 Island Avenue as a local historic site.
Is there a motion to hear this item?
I'll make sure.
Okay, it's moved and seconded. Commissioner Rosa Gonzalez, this is your item. You're welcome to present it.
So this item has been languishing on this agenda for a year. Okay, it got approved a year ago, and I never came in to even have a discussion about it because I wasn't sure if we had the support. Here's what I would tell you. I realized that as of right, the standard was purchased, and they are working on a plan to redevelop the standard. But I ran into the owner of the new property, Barry Sternlick, okay, Starwood Capital, builds his offices here. And I said to him, Mr. Sternlick, please don't ruin the standard with this big building that you are drawing and preparing to build. And you know what? He stepped back and he looked at me and he kind of cocked his head to one side and he said, you're not the first person to tell me that I'll be ruining it with the building that I'm planning on building. So there is a willingness for him to reverse what he's currently drawing to build there, which is a huge cement wall, which will completely ruin the aesthetic of the Standard, the gardens that we all love, the experience of being there. I know Commissioner Dominguez, you live on Belle Isle and you love the Standard, and this, what they're proposing right now is, it's just a big cement wall. Anyway, he's willing to reevaluate this. I know that for sure. And I know that this item is about a forced historic designation that I don't think is probably the best way to move forward to save the Standard. I think that we could direct the administration to come up with incentives to allow for something different there, something more low scale, something that that would be more in tune with the gardens and the waterfront and the surrounding neighborhood, which, by the way, is like small single family homes, okay, that also don't want this large cement wall. So Tom, what could we do right now as a body to help the Standard along and to change the current design that they've picked? Because I think there is a willingness if we do something. Oh, Mr. Larkin, you're here. Hi, you guys are here. So what do you think? So what can we do? What can we do to help? Is there anything at all? I mean, are you completely convinced
Through
that
the
the cement
chair.
wall
Through-
has to happen?
Oh, wait, hang a second. I'm new to this, so Nick, I need your guidance on what the
I don't know
process
what we
is.
can
But I
do.
think we need to
I wanna
open
make
the
a
discussion on all of this. So please, I'm
That's
filling
right.
in.
So, and it's up to you, Madam Vice Chair. You're acting as chair.
Yes.
Right now, and so you recognize individual
be
speakers
recognized.
on the committee, and you also can recognize individual speakers from.
Do we
the-
have
from
to
the public.
first open?
I thought there was a motion, Tom. Wasn't there a motion to hear this item?
I believe so, yes.
Okay,
Yes.
so I would like to recognize first Commissioner Dominguez, and then we can get other folks
Sure,
involved.
thank you. I will say that the folks at the Standard have been working very closely with the Belle Isle Residents Association. They are like this, and they have made modifications and changes to their construction to meet what BIRA, the Neighborhood Association, has approved. And what they're planning is only development on the east side. It's a beautiful structure, and there will be residential there as well. So none of the front or the garden is.
What Mr. Sternlicht told me when I had a conversation with him was that he didn't like the height of the
I'm
building.
sorry, I'm trying to
sorry.
follow the protocol set by.
No, I'm sorry.
by
Okay.
the- by
No,
the
I
chair.
interrupted, so
So-
continue.
It's okay.
No, continue.
But that's what I wanted to tell you, that they have worked so hard with the Neighborhood Association, because at first they were like, no, no, no. And now BIRA is really happy with what's been proposed to them. So maybe we should hear from the team that's here, that's in the audience.
So I'd like to, Commissioner Rosen Gonzalez, if you would hang on for a second, we can recognize the folks who are here to talk about it, to maybe shed some light on the current status.
Okay.
Sure. So, good afternoon, Madam Vice Chair, committee members, Michael Larkin, 200 South Biscayne Boulevard, here representing the Standard Hotel. With me today is Nick Rodriguez, my colleague, Miguel Isla, one of the owners, Stephen Abdikoff is an architect that specializes in historic preservation. He's available via Zoom. You know, you all have never involuntarily designated an individual property. You know, it didn't go forward at 42 Star Island or the Rod and Reel Club or 93 Palm Avenue, which was the Capone residence, which led to the adoption of a statute by the Florida legislature, which has forever now prohibited local governments from involuntarily designating single-family homes. You know, our proposed plans preserve the front building, the west wing, the gardens, the pool area. The only area that we are seeking to modify is the east wing. So, and I think that there have been substantial changes to the building that have altered its historic integrity. So I feel that this designation attempt is wrong. And, you know, Commissioner, I know your heart's in the right place, but we feel that we've made substantial changes to this building. We feel it is compatible. And I just want to let Miguel come up here as one of the owners, if you don't mind, Madam Vice Chair, and offer a few comments.
Miguel, you're recognized.
Hi, everyone. How are you? Thank you very much for having me here. So basically, Barry is my partner in this property, and he talked, we talked together. He mentioned that what he wanted to highlight to you is that we've been honestly working with the entire BIRA and all the neighbors, which are aware of the project and even have seen designs, to try to conserve what the standard is for Belle Isle, for Sunset Harbor, for North Bay Road, and for specifically the location that it is. So I think maybe what you heard was a little bit misinterpreted, because realistically, we'll be putting a lot of effort on doing something that's designed and it's something to keep what the standard is today, but uplifted in terms of quality of amenities, service, and everything. You know, this hotel used to be a motel, and right now the guests and the people that use it, which are the neighborhood communities and more locals that actually visitors to Miami, deserve, as the entire Venetian Island is progressing, deserve for the hotel to be capable of progressing with the development rights that we have. Yeah, sure.
Okay. Look, if it was up to me, I would move forward with a historic, oh, I'm sorry.
You're recognized.
Thank you. If it was up to me, I would move forward with a historic designation on this property, simply because the gardens are so iconic. Everybody loves that hotel. I think people across the county and even internationally are going to be horrified when they see what we're allowing to be done to this property that was, you know, purchased within the past couple of years. That said, I understand the commercialization and the powers that be in terms of lobby money and development and lobbyists and all of that. So look, if I think that how many votes do I need for a historic to move forward with the designation? How many votes would I need?
If the designation were referred by the city commission, it's 4 votes to refer it to the Historic Preservation Board, which takes the first step. But ultimately, a designation will require 5 votes of the city commission.
I mean, I can see right now that I don't know. I'd like to hear from you guys, to hear what you say, have to say, and work with them possibly.
Yeah.
If we move forward with the designation, we could possibly, instead of getting that one cement structure on one side, something low scale on both sides. I don't know.
So I just want to put on the record, and then I'm going to recognize the vice chair. I have concerns with involuntary designations. Mr. Director, how many involuntary designations have we had in the city?
In terms of individual sites, I'm not aware of any involuntary designations of an individual site.
And just out of curiosity, because I'm just wondering, because I'm just thinking about some of the legislation that's going through the state that we're dealing with as relates to historic preservation. A lot of it deals with base flood elevation and meeting the requirements of the National Flood Insurance Program. Where is this property as it relates to its elevation?
I believe that the entire property, the first level of the entire property is below base flood elevation.
And so I'm just concerned that we might, by pursuing this, while I think it's a great idea and it's very well intended, because it certainly is a very iconic structure, I think it could potentially have unintended consequences. I do believe that probably as part of the redevelopments that might be anticipated to take place, and I had to step out, so I wasn't able to hear everything that was said. You know, part of any tax amendment that might be required for any work, or part of any land development regulation amendment that might be required, that we encourage the applicant to voluntarily proffer the preservation and restoration of a number of historic elements as a form of incentive for whatever tax amendments might be necessary in the future. And I want to check with our attorney, is that something that might be feasible?
Certainly, Mr. Chairman, in your legislative capacity, if you wanted to condition any zoning incentives on the retention, rehabilitation of existing, let's say, architecturally significant features, you could do that, or even structures, you could do that.
And that's something that I would feel more comfortable with. Madam Vice Chair, you're recognized.
Thank you. So everybody loves the standard. It's beautiful, and it's this weird mishmash of old parts of the building and newer parts of the building. The gardens are stunning. It's a great, beautifully sited facility for Miami Beach residents and visitors. And I share your desire, Commissioner Rosen Gonzalez, to try to protect what we love. My understanding is that even if we got the city to agree to do this, we can't by state law, is my understanding, is that the state has preempted.
We're not preempted yet. We're on single-family homes, but not commercial designation. But
Nick,
I think it would put us in a better.
Let's
Nick,
let.
could you just confirm?
Yeah.
That's correct. You would not be currently preempted from designating.
Okay.
Yeah.
Thank you. So if I may continue.
Of course.
So here's my thing. Listen, I served on the board of the Miami Design Preservation League. I am a staunch advocate of preservation. I do understand that this is a beautiful Frankenstein of an older building that we love, and we want to protect the parts that we love. I would much prefer to have you collectively proffer up. We are not going to touch the gardens, the front part, which is actually one of the newer parts that we
Stained
love
glass.
the most. That's iconic and this great branding. Because the more we do things against the, first of all, I don't think it's great precedent to do something without people buying into it unless it's a significant, super significant historic site like the Al Capone house, which we couldn't do anyhow. We couldn't get people to agree to that. I would much rather incentivize with carrots than with sticks. I think we are all agreed your vision and Mr. Sternlicht's vision is to make this a bigger, better, more beautiful piece of local architecture and history that evolves. And I think that if we can do this by collaboration rather than, sticks, carrots rather than sticks, I would much prefer to go that way. So if the most affected residential group, the Belle Island Residents Association, is already feeling pretty comfortable with what's going on, then I would suggest maybe there's more conversations to be had to make sure everybody is on board, and maybe fresh eyes can sometimes tweak things in ways that aren't initially contemplated. I'd prefer to go that route than forcing a designation, because the more that we do as a city of Miami Beach to undercut individuals' rights, the more we get hammered by Tallahassee. And God knows, we got enough hammers coming down on us. So,
That's right.
So Commissioner Rosen-Gonzalez, I feel your pain, I share your concern, but I think we've got to do this collaboratively rather than trying to legislate, because I don't think we'll have the votes for starters. I don't think it's great precedent on something that isn't purely deeply historic, and I think we will be punished for it at the next legislative session in Tallahassee.
So if it's going to die, then it will die here right now. I don't know that we can do anything above and beyond
Well,
what's
Mr.
being
Chairman,
done.
can I give some greater comfort to Commissioner Rosen-Gonzalez?
You're recognized, Mr. Larkin.
Thank you, sir. So what we're doing now, Commissioner, is the extent of what we can do. The Standard Hotel is a legal nonconforming use, and I don't know, probably a decade ago, I amended the code and the comp plan just to allow this modest renovation expansion for the east wing. So that's all we can do. So by de facto method, you achieve your same goals, that we cannot touch the front building, the gardens, the pool, the west wing, which is collectively the rest of the property.
What I would say is, I would rather you build on both sides of the property, but build lower, so that way you don't have this large structure that's casting shadow on the gardens.
We did a
stops the
shadow
breeze
study,
from the
Commissioner.
homes.
Okay, I'm gonna, but
Well, I mean, I'm
if I
just
may,
trying to-
if I may, because that goes
Through the
now,
chair.
that would go directly to future tax amendments, and that's not relevant to what's before us. What's before us right now is whether we want to propose a designation of the Standard Hotel as a local historic site. And I think what you're proposing, I think, has merit and something that can definitely
We're
be
just having
discussed.
can I continue? Because we were just having a casual conversation, and then we're gonna kill this item. It's gonna be done.
Okay.
But I can at least say this. I would just encourage, and I think that design people around the world, people who live in Miami Beach and love the Standard, anybody who understands the importance of the gardens, the importance of what you have there, I would encourage something lower. Couldn't you lower it so that it doesn't stick out of the, I mean, if you could, and if you can't, it's fine. Look, this designation is failing right here. What I would say is I think it's a very sad day as this is being built. I think people are going to really mourn it, and I gave it a try, and I understand the involuntary designation does not work, but is there any chance at all that you can work on the design any more than you already have?
Can I respond, Mr. Chairman?
Well, and I will tell you that as the chair of this committee, probably, whatever land use amendment is gonna have to come through this committee, and I know that I'm gonna feel great comfort and relief knowing that we're working proactively with a stakeholder in preservation of architecturally significant assets. of our community.
Agreed. And just so Commissioner Rosen Gonzalez won't be so alarmed, I wish you would take a meeting with me and Miguel and Barry and one of our architects just to walk you through the plans to show that we are not overwhelming the standard site with what we're proposing to do. I asked to have a meeting, and I was told you didn't want to have a meeting, so I appreciate if we could have a meeting with you just to go over everything. That would be
You
really
may
helpful.
contact Commissioner Rosen Gonzalez's office. Commissioner, is there a motion that you want the committee to consider, or you want to withdraw your item?
Why don't you guys vote on it?
What is, okay, is there, well, number
Is
one,
there-
there has to be a
no,
motion.
there's
Is
nothing
there-
to vote on. Is there
a
anything to vote
motion-
on?
Is there a motion on the table? There's no
There's no
motion.
motion.
If there's no motion, Mr. Attorney, then what happens?
The committee could decide to conclude the item by acclamation.
All right, so is the item concluded? The item is concluded by acclamation. Thank you, Commissioner Rosen Gonzalez, but I think the conversation was productive because I do see the avenue to work with the property owner and hopefully bring forward protections as part of future legislation. Mr. Director, let's introduce item number 6.
Okay, item number 6 is discussion regarding expediting the opening of the Baywalk and move the development of the Baywalk up on the GEO bond prioritization list and present the Baywalk plan to the LUSC committee.
Commissioner Dominguez, I believe you're leading this item. I recognize you to introduce it.
Thank you. This is an item that was first brought forth by Commissioner Samuelin. He used to walk on the Baywalk every single day and was really passionate about it. And Commissioner Fernandez, Chair, thank you for picking it up after he had passed away and allowing me to be part of it with you. I've been working closely with the city administration to move this forward, and I'd like to hear the latest update from David Martinez.
Certainly, through the chair. Good afternoon, Mr. Chair, Madam Vice Chair, and members of the committee. David Martinez, Capital Improvements Director, for the record. If it's acceptable to the committee, I'd wanted to start with just showing the diagram that's part of the item, just to kind of walk through everybody what we're talking about. This has been a standing item where we have reported probably for over a year now on a periodic basis on the status of these. So this is part of the one of the exhibit to the memorandum that we submitted. I just want to walk everybody through what we have, and I'm going to work myself from south to north, from the bottom of the page up. In essence, there are 6 segments or links of the Baywalk that have not been completed yet, that do not exist. There is one segment that does exist, but is still closed to the general public. The southernmost that is considered part of the Baywalk system is the 5th Street MacArthur Causeway pedestrian bridge. North of that is the South Bay Bay Club. The third one after that is the Southgate Towers. Then you have the Mirador, Mondrian Mirador combination, the Bay Garden, the Bayview Terrace, Bay Garden Manor, and the Lincoln Bay Tower. So those compose the 7 links that are not open to the public, or they're either not built or closed. So let me start with the status of each one of those and specifics. The pedestrian bridge. This is a project that's being, it's part of a developer's agreement, private-public partnership with a developer of the condominium on 5th Street. The developer is supposed to design and deliver and construct this project based on the city's contribution of just over $9.6 million from the general obligation bond from 2018. The developer's design team has finally officially submitted the final application to the Department of Transportation in the last week. This includes everything that the Department of Transportation needs in order for them to make a determination, issue a final permit that will allow them to construct the PED bridge. In addition to that, there's an advisory or a review by the city, building department and other departments associated with the bridge, such things such as reviewing their mains of traffic plan when it does get built, and reviewing other aspects of the project. So based on that, It appears that the schedule still, it's been slipping. The developer was thinking they were gonna be starting construction of this late last year, then beginning of this year, and then it was first quarter. From my perspective, I don't think nothing's gonna start till what I'm calling spring. So I think it's gonna take, right now it's in the hands of the Department of Transportation. They can turn around very quickly and issue a permit, and maybe we do get it started in the next month or month and a half, but they could take longer in their final deliberation, which I think could take it into later into spring. But I think on a good note, I think the developer has overcome pretty much all the hurdles that they had ahead of them. So in order for them to proceed, once they have permits in hand from the Department of Transportation and the city would issue them a notice to proceed. They have to give us a laundry list of documents and items that are required by the developer's agreement, and then they would be able to proceed construction. They do have a contractor on board. They have not completed their final agreement with the contractor. They're required to turn that over to us as a prerequisite to us issuing them a notice to proceed. So we will have that in hand along with other documents. They're stating that they're prepared to begin construction within 30 days after a permit is issued by the Department of Transportation. I'm happy to address any other details on the pedestrian bridge that you may have.
No, I thank you for that update. For the pedestrian bridge, I know that you and I have had many conversations on this. The legal department is currently reviewing the documents that the different residential buildings would need to sign. So that's coming down in the next week, I think.
To clarify through the chair,
Yes.
I think the agreements we're talking about, Commissioner Dominguez, are associated with the other three properties that are part of the general obligation bond. In terms of the agreements that you're referring to, the pedestrian bridges, this one strictly.
Yeah, I've already moved on from the pedestrian bridge.
Right.
Thank you for that update. Now I'm talking back on the
Sure.
on the Bay Walk.
Sure.
So we have agreements that the legal department has put together for some of the residential buildings to sign, and then let's see. The Southgate Tower, it is built, but it was going to be contingent on Mirador, Mondrian, and Mirador. Where
Yeah.
are we at with that one?
Yes, and let me clarify. Yes, the Southgate Towers was constructed as part of a previous development order from the DRB, and the conditions of them opening this section was that that the South Bay Club be constructed. With your help and Commissioner Magazine's help and discussions with the property owner, they're contemplating making basically a swap and saying, instead of opening it when the South Bay gets completed,
When the north.
let's do it when the Mirador Mondrian gets completed.
And what's the status of the north?
The status, I'm sorry, of the
North
next section. So the
properties,
Mirador Mondrian property, which is a relatively long section, as you can see from the map, this is one where the developer, it's also tied to the developer's agreement associated to the tower on Fifth Street. They're required to, within 12 months, after the city issues them and secures a regulatory permit from the state, the feds, and the county, they're supposed to have this thing completed. Right
And
now,
when is that date?
they have passed that date. That date was actually, the date's coming up now, beginning of March. So in theory, they should have had this completed by the beginning of March, and they have not.
So,
Mr. Attorney.
Mr. Attorney, what is the next step? The developer does not have their portion completed. How do we move forward to make sure that they get it done?
David, I think is this the same property where we previously reached out directly?
The Mirador.
And I don't think we did that with the Mirador yet, so that's something we can look at. I'd like to look at that with staff to see
Certainly, from my recollection, the developer's agreement states that if they fail to construct this by the timeframe, that they would be responsible for the city's cost to have it constructed. But that's just devil's in the details, and that's certainly something that the city attorney's office, we would need their help. And
So if I could just ask, I'd like us to look at how we can enforce that obligation and maybe come back to the committee.
Okay. So if we, through the chair, if you're okay with me bringing it back next
Yes.
month
Yeah.
with
Let's-
information from the city attorney's office on where we are with the developers agreement and them not having it done on time.
Commissioner Bond, then Commissioner Suarez.
So, the Baywalk and its various construction phases are new to me, so thank you again for the detailed briefing on it on Friday. How, for my own edification, going forward, if a development agreement says you're supposed to have something built by March, and it hasn't even been begun by that date, why are we as a city not addressing that in the year before that, if they haven't applied for things? Like, because now, clearly, it's not gonna be done in the next 5 days, or 3 days, or whatever it is. So how can we take this as a lesson learned on how to do things differently or better, or is this an extenuating circumstances? Or, please educate me, and I'm not throwing darts, I'm just trying to understand how we're here and how not to be here again, because I really believe, West Avenue is dealing with all kinds of chaos on the water, they're dealing with a major construction project coming up momentarily to make it better in the long run, but, so the sooner we activate all of the Baywalk, the better it becomes, because it's safer, there are more people using it, it feels like there's a respite, and we're not there yet, and this is part of the problem. So
Madam
help
Vice
me-
Chair, let's allow the director to speak, and then we have Commissioner Suarez.
Certainly, thank you. So yes, the developers agreement, they use terms as words like material default. And I don't want to get into the legalese because that's not my realm, but the not constructing this Baywalk as part of the developers agreement is not considered a material default from my perspective. Therefore, we would have to, again, work with the city attorney to figure out how to get that done. Now, the developer hasn't, from my perspective also, in good faith, been attempting over the last several months to obtain a permit from the building department to get it constructed. They do have a contractor under contract, and it appeared that they were going to be able to resolve whatever their permit issues were in obtaining this permit that they're responsible for. It's been going slower than we anticipated. The construction itself, once they actually begin, wouldn't take very long. So we really were trying to be optimistic not to have to get involved with attorneys at this point, because they were moving forward a little slower than we wanted to, but we're still not there yet. And
Yeah, and then Commissioner Suarez.
Just one quick question. So they've been moving through the process. Are they just not responding timely to the feedback they're getting from the building department? Are they sort of slow walking this whole thing?
in my opinion, yes.
How do we fix that?
Well, I have a feeling that probably that same developer is probably interested in other stuff.
I'm quite sure.
coming Before us. So,
I'm
let me,
quite sure.
let's,
Thank you.
I think we should all reach out. But Commissioner Suarez, you wanted to speak on the item.
Thank you, Mr. Chairman. How long have we been, how long has this project been going on for, roughly?
This Baywalk has, and Tom has a lot of the history. This Baywalk goes back many years ago when the DRB, and I don't want, Tom, correct me if I misspeak, the DRB approved improvements to their site, and in exchange for that, one of the items that they were responsible for was to construct this Baywalk at their own cost, in simplicity. At some point in time, and they had put money on
Talking
escrow.
about like what year?
Through the chair, that was, started about 2008. That's when the conversion of the then Mirador Central was converted to the Mondrian.
Okay, so, through the chair. 2008. It's 2024. Who's responsible for this Baywalk, ultimately? The completion of this Baywalk?
The developer's responsible for the completion. My department got involved at the time that right before this project was included as part of the developer's agreement to facilitate this getting constructed. 'Cause before that, the developer or the property owner did not have, and Tom, correct me if I'm wrong, did not have a direct relationship with the city as the owner.
But
It was all on their onus to get it constructed.
ultimately from the city, who's responsible for making sure this project moves forward?
I'm responsible for making sure this project moves forward.
So if you had a magic wand and wave it, what would you need to make this finish by the end of this year?
I would probably need help from the city attorney's office to enforce the developer's agreement to whatever its extent could be to get this to happen. Because right now I don't have any means of forcing them
Through the
to
chair.
do this.
Through the chair. So are you sure there's no permitting process that this developer is going up against? Because it doesn't make any sense to me that this developer is building a pedestrian bridge. The same one who's building the pedestrian bridge is slow rolling this one on the Mirador de Mondrian.
Correct.
In my opinion, I think that pedestrian bridge was to enhance the Five Park property. So why would he not want to enhance the rest of the Baywalk and slow roll that?
And if I may, I mean, and I'm no one to speak on behalf of anyone. I just know that this does have a very storied history, and not all property owners have always been, you know, as willing as others to pursue this as much. Not everyone wants a public Baywalk open behind their property, and a lot of this is relying largely on voluntary proffers. And so I think there's some of that there. If I may, I could, yeah. And,
Just to finish.
Yeah, and
So-
then I'm going to recognize Commissioner Magazine.
So, again, magic wand, you would say that it's mostly with the city attorney that can help you push this forward as fast as possible? It's not, nothing has to do with the building department?
But I can tell you, Commissioner, from my understanding and the information I'm seeing on the permit reviews, there have been comments issued by the building department that don't get addressed.
Right.
And then when they get addressed, they're not providing the full information.
Okay.
So then the building department's not able
So
to issue. a
Where I'm
permit.
going at with this is, I think it's really good to set clear goals and expectations. And, you know, I don't know how my colleagues feel about this, but I think the goal should be the end of this year, the Baywalk is 100% complete. That just,
Well, if I may, I think the thing is, you're dealing with individual property owners doing voluntary proffers on this, and while we may set this goal, not everything is on the city's side to be able to advance this smoothly. Correct me, Mr. Attorney, if I'm wrong on that.
Right. I mean, ultimately, many of these Baywalk projects, maybe if not all, are private projects for the benefit of the city, and so we were relying on the developers. In this instance, I want to review the development agreement with Raphael and Rick in my office to see, you know, what if any enforcement.
And we're going to be continuing this item next month, but I'm going to recognize Commissioner Magazine, who has not spoken. Then I'm going to come back to the sponsor, and then we're going to continue the item to next month, because we still have more items on the agenda.
Yeah, thank you to the chair for recognizing me. It's just not able to collaborate with my colleagues outside of this, so it's effective for him to talk about this. It's my understanding, David, we talked in the beginning of January, and where that stood at this time for this specific project was the building department was reviewing the permitting process. Actually, unfortunately, since July, they talked about the nuances of having to go over the water, so they were actually addressing whether that over the portion project would require handrails and lighting. In my perfect world, waving a magic wand, those conversations would happen over the course of an hour or 2 hours in an in-person meeting, not over the course of 6 months. So when we talk about this dragging out over the course of 15 years, it's conversations that can be had over the course of an afternoon that now have this permit outstanding from July until now we sit here in February. Those are the types of things that we need to address. I don't know if you have an update from when we talked, and I don't mean to put you on the spot like that, but I know that that portion was outstanding with the building department in, let's call it the beginning of January, if that's been resolved.
Through the chair.
Yes.
Yes, Commissioner, they finally did resolve that issue. They're gonna make it so that you can retrofit handrails if needed. Right now, there's only a couple of things left that they have to address. They claim that they're easy things to do, simple things like a parking plan that hasn't been submitted of where the contractor's gonna park when they go to the site, and there might be another couple of simple things.
But that requires the collaboration of the private party to submit this. The city can request it, but the private party needs to cooperate and submit that in a timely manner.
Yes, Mr. Chair, absolutely. Remember, this is a private-public partnership. They control that permit.
So we can only expedite as much as what's on our end, as much for as quickly as someone responds, us to be able to respond quickly. But if we respond with comments and we still have missing information, that then falls on the private party to provide that in a timely manner.
That's correct.
And that's where I think we can all play a role in reaching out and encouraging this and highlighting it as a priority of this commission and this committee, the completion of this. Because certainly, again, this developer, this is not the only matter that they have before the city. They have other matters before the city and before this same committee. Commissioner Dominguez, this is your item. How are we going to proceed?
So I'd like to hear an update, what's changed from this month to next month. Thank you.
Certainly.
All right. Is there a clear direction to staff, to the attorneys? Everyone has clear direction?
Yes.
Well, not direction, but feedback?
Mhm.
All right, great. Thank you so much.
Thank you.
Mr. Director, let's call up item number 8.
Okay, item number 8 is the discussion to amend height and other development regulations in the Resiliency Code for zoning districts in North Beach in order to protect the character of the neighborhood, including North
Oh,
Beach
I'm sorry.
Historic District.
Before we do that, and I apologize because earlier we had the item on the Standard Hotel and I forgot to open up the public hearing, and I said I would open public hearing for every single item. And I know there was one member of the public that had his hand raised for that one, and I apologize to him. But on the Baywalk, I see Wayne Roberts has his hand raised. So let me just recognize Wayne to speak on that item. Wayne, you have 2 minutes.
Alex, you're a gentleman and a scholar. Thank you very much. I only briefly walked the Baywalk along West Avenue, north of Fifth Street. And I can tell you that it's not just the Mondrian that's the problem. The walkway is nothing like anywhere else in the city as a Baywalk. It's extremely narrow and extremely dangerous. There is no handrails, and it's only maybe, I swear, it felt to me like it was 5 feet wide behind 5th to 6th, because I stopped there. It needs a whole evaluation if you want to really make this special. And I don't know what the legalities of who has ownership of what property, or we have right-of-ways to make it wider. But I can tell you that Baywalk is a accident waiting to happen. And I'm talking death without any modification to not just the Mondrian, but other properties along that Baywalk. And I don't want to see a child dying or an adult dying, but I can tell you that is way too narrow for a public walkway. Thank you.
Okay. Mr. Director, let's call up item number 8.
Okay, I just read item 8 into the record, and so I think we're ready to go.
Yeah, is there a motion and a second to hear this item? You move the item, you move it second. The item is before us. Tom, would you present the item? This is my item on North Beach regarding heights in North Beach and how we can properly present amendments to protect ourselves from the impacts of the Live Local Act.
Sure. Mr. Chair and members of the committee, as indicated in the memo, we've summarized the areas in North Beach that could potentially be impacted by the Live Local Act. And as The members of the committee may recall this past Wednesday, on February 21st, at second reading, we adopted a set of regulations that were specific to the South Beach area. They were called the South Beach Development Regulations. And basically what they did was they lowered the maximum building heights in all of the applicable districts to 150 feet. And the reason for that was so that properties in the South Beach area that were zoned CD2 or CPS2 or MXE, which are all eligible to accommodate Live Local Act projects, would be limited in height to no more than 150 feet, because those properties were all within a 1 mile radius of the zoning districts that had a higher height. Within the North Beach area, there are districts that would also be eligible for the provisions of the Live Local Act, and these are predominantly the CD2 areas in the North Beach area, as well as the TCC district and some of the TC1 districts and the MXE district. The TCC district already has a maximum height limit of 220 feet, but the CD2 areas, both on Normandy Isle and south of the TCC area, as well as to the north of the 72nd Street Park, that are also zoned CD2 and MXE, have much lower height limitations. And so the ability to zone up to a much higher height, because they are within a mile of the TCC district, would potentially be there if a developer wanted to avail themselves of the ability to do the Live Local Act within those districts. And so the purpose of this item is to discuss some potential options with regard to amending the development regulations in these districts. Some of the things that we've recommended be discussed in the memo include some of the setback regulations that were similar to what were adopted for the South Beach area, and that includes establishing minimum front, rear, and side street setback requirements in the CD2 district, as well as in the Harding Townside area. And in the area west of Collins Avenue in the CD2 district, establishing similar setback requirements so that if a taller height is proposed, there would be a more limited area that that height could be proposed for. If there is a proposal to amend the LDRs, a separate referral would be required, and the commission would need to make that referral to the planning board.
Vice Chair Bott, you're recognized.
Thank you. I apologize for doing this at this late moment. When I read this item last week, preparing for the meeting, in the chaos that has been this past week, I did not act on my desire to be a co-sponsor for this, so hopefully I can do this at this time.
Of course.
Okay. Yeah, I mean, North Beach has had a target on its back for the last number of years, and all the more so now. So everything that we can do to protect the character of North Beach while not disincentivizing development, but protecting, we don't need more 22-story towers in town center or frankly anywhere in North Beach. Traffic is a disaster as it stands. Our infrastructure can't withstand it. Our sewer lines rupture more there than anywhere else. We have a very special part of the city. We want to keep it that way. Again, we don't want to disincentivize thoughtful, appropriate, contextually relevant development that provides what we need for our neighborhoods and our residents, but we need to make sure it's done the right way, and I think this goes a long way to that.
Great. Commissioner Dominguez, Commissioner Magazine, any comments on this item?
Thank you, Mr. Chair. I'm supportive of this item. I think it's a great move to protect a beautiful part of Miami Beach, and I'm happy to co-sponsor this as well, Mr. City Attorney, and I move the item.
Okay, great. So you move recommending staff recommendations back to the commission and to the planning board. Is that correct?
And this would just be the recommendations that are set forth in the memo, correct?
Yes.
Okay.
As mentioned. Is there any public comment present on this item? I see Daniel Serraldo is on Zoom. Daniel, welcome. You have 2 minutes.
Thank you so much, Commissioners. Daniel Serraldo with Miami Design Preservation League. This is so important what you're all doing as far as amending the plan for North Beach. We know that unfortunately local control is under attack right now, and many municipalities are taking measures to ensure that what is so important to them, keeping the character of their neighborhood, is addressed and protected. So thank you all for what you're doing. And I look forward to continued collaboration to protect these wonderful neighborhoods, especially in North Beach. Thank you.
Thank you, Daniel. Is there any other members of the public wishing to speak on this item present in the chambers? Seeing none, I see no members with their hands raised on Zoom. Without seeing no further comments from the dais, the item has been moved and seconded. Mr. Attorney, let's call the roll.
Who was the second?
I was.
Okay.
Okay, Commissioner Dominguez,
Yes?
Commissioner Suarez, Vice Chair Bott,
Yes.
and Chairman Fernandez.
Yes.
The motion carries.
May I ask a question relevant to this?
Yes.
Do we need to do something separate to this, or in addition to this, to refer to the commission for amending the LDRs?
Well, this would be what we would do is we would take a C4 referral to the commission to refer LDR amendments to the planning board.
That's right.
Okay.
Thank you, Madam Vice Chair. Mr. Director, let's call up item number 9.
Okay. Item number 9 is to amend the land development regulations to exempt STI testing from the restrictions in the city's medical use regulations in order to increase the availability of STI testing and mitigate the recent spike in HIV and other STI transmissions in Miami Beach.
Thank you, Mr. Director. Is there a motion to bring the item properly before us? Yes. Okay, there's a motion, a second. Colleagues, this is an item I placed on the agenda. As mentioned, our zip code has been identified as an HIV hotspot, and entities have approached my office with a desire to be able to offer discrete testing for HIV and other STIs in places that don't necessarily have the stigma of a clinic or other type of location. So this, in essence, will allow for STI testing to take place outside the confines of a medical facility by accepting them from the regulations for medical use. We already do this for a certain number of other medical uses that we provide this exception for, and this is just a simple amendment to our LDRs. Tom, I don't know if there's anything else about this that needs to be mentioned for the record.
Nope, I think you covered it all. If the committee is supportive of this, it would just be recommending a C4 referral for the commission to the planning board.
Okay. Commissioner Bott.
I would like to move this.
Second, any discussions, questions, debates on the item? Seeing none, Mr. Attorney, let's call the roll. Are there any members of the public present to speak on this item? Seeing none in the chambers and none online seeing none online either, Mr. Attorney, let's call the roll.
Commissioner Dominguez?
Yes.
Commissioner Suarez, Vice Chair Bott,
Oh, yes.
Chairman Fernandez.
Yes.
The motion carries.
Okay, item number 10 has been withdrawn as stated at the setting of the agenda. So with that, let's call item number 11.
Okay, Mr. Chair, this is an item, and I'll also mention that, because we didn't mention in the memo, that Commissioner Joseph Magazine is a co-sponsor of this item. This is to consider convening an ad hoc historic preservation ordinance review task force to conduct a comprehensive review of the city's historic preservation regulations and make recommendations to improve and streamline the review process for projects located in historic districts or on individual historic sites.
Thank you, Mr. Director. Is there a motion to bring the item properly before the committee?
I'll make the motion.
Okay, it's been moved by the Vice Chair, seconded by Commissioner Suarez. The item's before the committee. This is an item I placed on the agenda because our historic preservation ordinance was adopted in 1982. That's 4 decades ago. And a lot has changed, and we've learned a lot, and we face a number of challenges today that perhaps we didn't experience before, certainly including challenges, not just natural challenges, like challenges with sea level rise and resiliency that we are so much more familiar with now than what we were 4 decades ago, but also challenges, political challenges of preemption and others. And so I felt it would be beneficial to convene a historic preservation ordinance review task force to see what has changed in the past 40 years, what modernizing we need to do, how can we better incentivize historic preservation in our codes, how can we even enhance the powers and enhance the scope of review of the Historic Preservation Board to ensure that it stays true to its intent. I want to be able to recognize the planning director in case there's any thoughts you would like to place on the record as it relates to this.
Sure. Mr. Chair, in preparation for this item, I did discuss it with the city's Historic Preservation and Architecture Officer, and she thinks this would be a good idea and a good opportunity to, as you said, update our regulations on this. We think that a nimble committee could provide some very good recommendations. And then in addition to a broad-based committee, we would also recommend that perhaps there be a time frame for the deliberations so that they have an end date for which to bring recommendations back to the commission.
And I completely agree with that. I would like to see us recommend to the city commission, if it's the will of the body, that the city attorney's office collaborate with the planning department in crafting an ordinance for a committee with a short sunset period of maybe come back to the city commission with recommendations by September. Because I want to make sure that that not just locally we show that we're working on this, but I want to make sure that higher jurisdictions see that we're taking the issue of historic preservation seriously. And so before the next session of the Florida legislature for next year, I want them to see that we're making progress on historic preservation. And so I agree, this should be a body that meets for a short period of time that could come back hopefully by September with recommendations to the city commission. I, for one, feel that the composition should be small, but I think we certainly need a preservationist residing in a historic district. I think we need an attorney, a representative from NDPL, a past HPB member, a person of financial background, and certainly we need someone from the development and construction community there to provide that valuable input as well. I want to open this for dialogue from my colleagues. I know Commissioner Bott, you are a preservationist, and you've served in a number of capacities, not just on the planning board, but also on MDPL, and so I would value your feedback on this.
Yeah, thank you for that. And with everybody's permission, I would like to co-sponsor this and help shepherd this through. I think it is long overdue. I think that where we were 40 years ago as a city is not where we are now. The challenges have changed significantly, as you've very clearly enumerated, and anybody who's heard me speak on this matter in the last 3 or 4 years has heard me say that we need to be planning for the city that we want going forward, not the city that we have currently. So I agree with the notion of fast, small, smart, invested in the outcomes so that we can create what we want to live in going forward and not hear from people who would like to invest in our city and would like to do something that enhances the historic nature of the architectural inventory that we have, but it's too cumbersome, it's too onerous, the needs no longer match with what the code allows. So the goal is not to come up with 20-story buildings all along our historic corridors, but the goal is to make it easier, especially if we can incentivize to full-time residential units. That would be, I think, even the icing on the top. So yes, 1,000%.
And I think that's one of the things that we have to, when we look at the scope of review of the Historic Preservation Board, empower them to be able to expand their scope of review to include things like housing, expand their scope of review to include things like resiliency and sea level rise. Allow them to consider tools like FAR. And it's important because it's a tool that's available now that I think should be considered. Certainly, I think that is great feedback, great contributions you've provided, and I'd like to see us come back with an ordinance to the City Commission for this. I don't know, there's more comments from the body. Commissioner Suarez, Commissioner Dominguez, if there's any comments you would like. Yes, you're recognized, Commissioner Dominguez.
Thank you very much. I do think this is very important. I know that whenever there's session in Tallahassee, I hold my breath because it's so scary what's happening. There's been a lot of good done with our government affairs team and also with Daniel Seraldo at MDPL. He is just absolutely amazing, and I appreciate everything that he's done. So I'm fully supportive. I think this is important, and I thank you, Commissioner Fernandez and Chair, for bringing this forward.
Absolutely. Commissioner Suarez, you're recognized.
Thank you, Mr. Chair. Just so that we're clear, it's going to be a separate ad hoc committee just to go over the regulations.
The Historic Preservation Code, similar to like our Charter Review Task Force. This would be just a committee just on this section of our code.
Wouldn't that make sense for the Historic Preservation Board to be doing that?
Well, the Historic Preservation Board, I think, is perhaps there could be a member from the Historic Preservation Board, but I think when we look at the Historic Preservation Board, you might not have representatives from the development community there who are actually engaged in doing construction in Miami Beach, because if they were represented on the Historic Preservation Board, they would be conflicted. And so it's important to get the experiences of those who are actually working in Miami Beach, trying to do historic preservation and working on historic properties, because otherwise, we're only getting one perspective if we do it through the Historic Preservation Board. But as I mentioned, I think we should certainly have the participation of either a current HPB member or a past HPB member, certainly participation of NDPL representatives, certainly participation of a preservationist residing in a historic district. But we do need as well, I think, the input of individuals in the construction industry that perhaps might not be represented in the HPB, or developer representation, because they're the ones that are dealing more with this, or even an individual of financial background from the financial industry that can talk about how do you make it financially viable to advance some of these projects. And so I see this a little bit different than the HPB criterias.
Through the chair, this is an advisory board, and it advises to the commission?
To the City Commission.
Okay, great. Well, with that, I move it.
All right.
Second.
And I want to recognize the city attorney. I see his hand is up.
I just had one comment, which is, since this is an ad hoc rather than a standing committee, the commission can create this committee by resolution.
So I would if perhaps the maker of the motion would consider that asking our city attorney and our planning department to come back with a resolution, not an ordinance, but a resolution to the next city commission meeting to create this ad hoc committee. So it's been moved by Commissioner Suarez, seconded by the vice chair. Are there members of the public wishing to speak on this item? Seeing none on Zoom, I see two members in person. Mr. Casson, welcome. You have 2 minutes to speak.
Thank you, Mr. Chair. Neeson Kasdan, 4520 North Jefferson Avenue. Thank you for a very thoughtful and comprehensive approach to looking at this regime and structure in terms of historic preservation going forward in this city, and thank the Commission for its open reception to looking at these issues and items. I think you covered, Commissioner, most everything in your comments, but I do want to point to one other thing that I think needs to be looked at as well, and that is the criteria by which we judge applications for certificates of appropriateness, particularly in light of what you first talked about, which is how the world has changed with things such as resiliency not being a factor 40 some odd years ago, housing needs, and other things of that sort. I just want to point out that the best explainer of this was probably Norman Giller, who was one of our foremost architects, was the father of the city's design review board, which he chaired for many years, and someone I was very close to. I worked with his son in law for 8 years. I grew up with him. And Norman had a very smart and reasonable philosophy about it. He felt that some buildings were of great architectural character and merit and needed to be preserved and worked with. But he also recognized that other buildings, including many that he designed and were built for utilitarian purposes for that time period, and they no longer had a useful purpose or practical purpose in the modern day and age. And so one of the things we need to consider is revising the criteria to look at the practical use of the properties today, as well as other important community goals such as resiliency, housing, transit, economic development, neighborhood revitalization. And I think
Thank you, Mr.
you're
Caston.
setting off in the right direction with this. Thank you.
Thank you, Mr. Caston. Any other members of the public present wishing to speak on this item?
Yes.
Welcome.
Good afternoon, Mr. Chairman, committee members, Michael Larkin, 3538 Flamingo Drive. I'm here with my law clerk, Mr. Jackson. Please welcome him to you all. What Mr. Caston is saying is absolutely right. You know, I think you all should focus upon expanding the criteria by which the HPB judges applications. About a couple of years ago, you all did that for resiliency criteria, and I think it's time again to consider a new set of criteria. What I have found, and poor Mr. Jackson has been like racking his brains trying to find economic development criteria that the board could consider. And I was just looking through yesterday, and I found that Montana, of all places, Montana, when it issues grants to restore historic buildings, they have a set of economic criteria they look at. They say how much is being invested, you know, job creation or retention, business expansion, local tax base growth. These are interesting topics that the HPB could possibly consider as a part of its overall analysis. They could look at traffic issues. Is the number of automobile trips being decreased based upon a decrease in intensity? Is there provision for bicycles? A lot of times applications go in front of the HPB that don't go to the planning board. And you can take all the planning board tools and apply them in an HPB setting and ask, like, how are you assisting mass transit? How are you assisting alternative forms of mobility? You know, in a checklist, yes, no, are you doing it or not doing it? So that's it, Mr. Chairman. I think it's an exciting time, and I think it is time to revise these criteria and expand them.
Thank you. Thank you, Mr. Larkin. I see online we have Sophie Ringel with her hand raised. Welcome, Sophie. You have 2 minutes to speak.
Hello. Hello. Thank you so much for, I appreciate it. I'm just here to say thank you for taking sustainability seriously. I'm really appreciative, and you're doing the right thing, and I am rooting for all of you. So thank you for having these meetings, and good job, everyone.
Thank you, Sophie. I see we have Wayne Roberts with his hand raised. Welcome again, Wayne. You have 2 minutes.
I trust this commission and this body today to realize, and they totally realize that you know, we have lobbyists that are on behalf of developers, and that's good. Capitalism is good. But I've taken a drive recently across the MacArthur and up Biscayne Boulevard, and I can tell you those developers destroyed. I mean, utterly destroyed. It was a poor example of city planning before, but the overdevelopment, the density was atrocious. It was worse than the Bronx, in my opinion. And there's balance, there's equity. And I hope the city finally strikes a balance in their planning that takes consideration of developers and money making, but also the future of Miami Beach and the residents today. And I know this group is different than the last group. I know they will do the right thing. Thank you very much.
Thank you, Wayne. Thank you for your comments. Any other members of the public wishing to speak on this item? Seeing none in person or online, There's been a motion, oh, I see, our planning director has a comment.
Mr. Chair, I just wanted to confirm two things. One, that the reso that we're going to be drafting to bring to the commission will include a recommendation for a time frame for this committee to provide a recommendation to the city commission by September of 2024.
I welcome that.
And then the second one, I just wanted to confirm the members. We've got a person with financial expertise, development, construction expertise, former HPB member, preservationist who resides in an historic district, representative from MDPL, and was I missing two more, or were those the?
I had listed an attorney.
Okay.
And I had developer and construction separate because an expert
Okay.
on construction might not necessarily be an expert in development.
Okay.
Mr. Chair?
Yes.
If I might suggest refining the construction category to be somebody who is familiar with restoration, preservation, rather than somebody who thinks it can't be done, because that will be deleterious to our efforts. We all know that it can be done and is done all the time, if that's okay.
When we talk about construction, we're talking like general contractor, what would he, I would imagine, I would say, you know, general contractor would be kind of what we're looking for, but I guess we could work on that while we're crafting this language, and I would ask you, Mr. Director, Mr. Attorney, please work with my office in the crafting of this language so that we can bring something robust to the City Commission. Any additional comments, clarifications that are needed? With that, Mr. Attorney, let's call the roll on this item.
Sure. Commissioner Dominguez?
Yes.
Commissioner Suarez?
Yes.
Vice Chair Bott?
Absolutely.
Chairman Fernandez?
Yes.
The motion carries.
Thank you, colleagues. Mr. Director, let's call up item number 12.
Okay. This is to review land development regulations applicable to new conditional use permit applications for neighborhood impact establishments, discuss whether NIEs should be required to apply for renewal from the planning board after a specific term of years, and discuss adopting property maintenance standards specific to NIEs.
Thank you, Mr. Director. Is there a motion to bring the item properly before us?
I'll make the motion.
I'll second the item. The item is properly before the committee. This is an item I place on the agenda. When we talk about neighborhood impact establishments, we're talking about establishments for example, an alcoholic beverage establishment or a restaurant with 300 or more occupants. We're talking about alcoholic beverage establishments on a rooftop within 200 feet of residential. We're talking about those establishments that could yield the more direct impact to the quality of life of our residents. From my experience on the planning board, I placed this item on the agenda because what I would see is that applicants would come forward to the planning board to submit their application for a neighborhood impact establishment. And they would dazzle the planning board. They would come put their best foot forward, and they would get their approval. And then almost immediately after they would commence operations, the community would be suffering. And now you've granted them something that, correct me, Mr. Attorney, if I'm wrong, that's vesting them to a certain point with certain rights that are hard to take away. Is that correct?
That's correct.
And for me, it's upsetting when us as public officials or planning board members, as residents who volunteer to do the best that they can for the community, stand up and serve on these committees and trust a business that comes forward that is presenting something positive that ends up being a negative. And then we're left with our hands tied, with no mechanism or no avenue through which to come back and revoke, unless there is a violation that is issued, that's substantiated, that's gone through the whole process of standing up with special masters and that type of stuff. The community is left with their hands tied. And so what I would like for this body and our city commission to consider is, how do we impose a certain level of review of these neighborhood impact establishments, legislate and codify a review 6 months after the approval, and then subsequently 1 year afterwards, every year, so that these establishments know, yes, you may have gotten the trust of the community with a conditional use permit, but you need to come back and show that you've been responsible with that conditional use permit that the community has entrusted you with those rights that you weren't entitled to, but that now our vote has given you. And putting those check and balances in place to once and for all protect the quality of life of our residents. Because by putting those progress reports in place after 6 months and then yearly, on a yearly basis, if an applicant, if someone with a CUP for a neighborhood impact establishment is performing well, they should have no issue whatsoever standing before the planning board for their progress report, because they'll fly through with flying colors. If they're performing well, if they're not causing impacts to the quality of life of the residents or to sanitation, or they're not generating an increased amount of calls for service to police. But if these individuals are impacting our community, they'll fear that progress report they'll have at the 6-month mark and then in the yearly mark, because that progress report can then trigger a hearing for modification and revocation of that conditional use permit for the neighborhood impact establishment. I want to thank my colleague, Commissioner Bott, my former colleague on the planning board, for co-sponsoring this item with me, because this was one of those issues that you and I bonded on when we served our community together as colleagues on the planning board. And I'm glad that we're both sitting together now in this committee so that hopefully we can finally legislate this safeguarding mechanism for the quality of life and the safety of our residents. Commissioner Bott, I don't know if you want to speak on this item. And then I'll recognize Commissioner Dominguez and Commissioner Suarez.
Yeah, thank you for this. And everything you said, we have folks who do the right thing, and then we have folks who promise to do the right thing and don't. And right now, the way the system is set up is that it is incumbent on residents to be the policing mechanism of the organizations that are not doing what they promised. And dazzling people and getting neighbors to buy into a concept before the concept is brick and mortar is one thing, but being good neighbors and good stewards of the community and leaders in the community isn't another thing entirely. I mean, we have a case right now where we've had violations and complaints for well over a year. It is very easily controlled by the property owners and the managers. They are not. And so finally, they came back to the planning board with the violations in hand for a review, a progress report, and somehow magically all of the violations were dismissed. And this is not okay, because nobody is calling the code enforcement team for fun, sitting around for half an hour, an hour, for as long as it takes, trying to convince people that yes, there is a problem. We've got the system wrong. The system is imbalanced. It is very easy to keep your CUP if you're doing what you promised. And when you're not doing what you promised, it should not be on the shoulders of the residents who have to put up with your nonsense to make you comply. There needs to be a better mechanism. I don't have the answers today as to what that would be, but I really, I think it's critical that we figure out what that is, how it works, what it looks like, and get it implemented ASAP.
Thank you, Madam Vice Chair. Commissioner Dominguez, and then followed by Commissioner Suarez.
Thank you, Mr. Chair. So I had a few questions on this item because I did think that the planning department already had progress reports in place in order to address things like this.
Let's recognize the planning director, because my understanding is that it depends on a case-by-case basis on the orders, whether the orders mandate a 6-month progress report or not, but it's not a uniform codified process across the board. Mr. Director?
That's correct, Mr. Chair. We don't have a codified uniform process for progress reports.
So some properties might have a 6-month progress report after their issuance, but not all.
Correct.
And there's not a yearly progress report now required.
That's correct. There's not.
Commissioner Dominguez, you're recognized.
Well, thank you for that. With that, I move the item.
Thank you. The item's been moved and seconded. Commissioner Suarez.
Yeah, this brings me back to one of the properties that I've been complaining about at Mila's, and it's the traffic situation outside of Mila's is just completely out of hand on one-way streets going north and south, and really there's really no one to complain about it. So when we actually do review these, who's responsible for reviewing and codifying these progress reports? So for example, for like Mila's, we see there's obviously a problem when it deals with valets and traffic. Can we install a camera outside to always have something to look back on if there are, so that way we're not really relying on code or someone to call in. We can just simply look at the camera back at a certain period of time and see how many violations are being occurred.
I couldn't answer the question regarding the camera because if the camera was going to be located on a street pole or public right-of-way, I would imagine the city could do that.
Mm-hmm.
I don't want to speak for the police department on that. Whether or not we could require as part of a modification hearing a requirement for a camera to be installed on a building to monitor traffic, I think that I don't think that we could mandate that unilaterally, but Nick, do you think that is something we could include as a condition of approval for a conditional use permit?
It's something we could look at. The enforcement mechanism in our code is that as soon as there is a violation of a condition of a CUP, the staff brings a progress report to the planning board. The planning board can then decide to set a modification or revocation hearing, and at that hearing, the planning board can either impose additional conditions or revoke the CUP altogether. But we would need to look into whether we can install, require the installation of a camera.
Through
Yes.
the chair.
Yes.
Maybe we can require that the business who's requiring a CUP to install their own camera, which gives us access to the footage.
Well, that's what I was just conferring with Nick about, whether or not we could impose that as a condition, whether the planning board could actually impose that as a condition where the business owner has to install a camera on their building. Right now, if somebody wants to install security cameras, they can do that. They come in and they get a permit for it, but it's a voluntary installation. This would be something where we would be requiring that they install a camera that we could then monitor.
Just make sure it's not a Honeywell camera, okay?
Thank you, Commissioner Suarez. Any further debate on this item? Questions, comments? Are there members of the public present wishing to speak on this item? Seeing none in person, I see Wayne Roberts has his hand raised on Zoom. Wayne, welcome. You're recognized. You have 2 minutes.
I've seen a propensity to approve ambient music across the city and rooftops. Now, Mueller is a good example of perfection in my mind. I agree with Suarez on traffic, but they bring an impressive a clientele, and they make Miami Beach a better place. And I don't want to pick on these places, but I don't know how to do this, but name them. So Pura Vida, Call Me Gabby, that whole strip, there are residences right above Pura Vida. And I know a couple of residences that moved because of the noise. Now, I went today for breakfast, and their neighbor, I think it's a taco joint, put opposing music of equivalent sound or louder. So they're drowning each other out, and the sound it makes it unenjoyable now that, especially with the taco joint, putting competitive music out. And you can't say, oh, this one is okay, but this one ain't. I get it. So we need to modify the approval process of ambient music outdoors with speakers. It has to be part of this process before it gets completely out of line. Now, when I called about Call Me Gabby, or I made mention of it to a commission meeting, they lowered the music, thank God, because I literally could hear it 4 blocks away, like it was a concert. Since then, they've been very good about it. But we need to control this ambient music outdoors so that this whole entire city is not flooded with tourism sounds. Thank you.
Thank you, Mr. Roberts. And I would like to actually ask the city attorney and the city planning director. Last year, I had worked on a referral to this committee that related to the installation of noise meters and the use of noise meters in our city. The item didn't move forward, but I'd like to reintroduce the item as a referral to this committee so that we can work on that further, see what avenues and what language we can consider to properly adopt it as a tool that doesn't do away with whatever mechanism is being used now by code enforcement, which was a concern. I believe at one point code enforcement stood before the previous composition of this committee and expressed concerns with the use of this equipment instead of the discretion of a code enforcement officer. But I'd like to work on language that would allow for both to be used. The discretion of the code enforcement officer, but backed with a calibrated instrument that is objective, with objective criteria for the enforcement of noise and noise pollution that emanates from establishments that oftentimes, affects directly the quality of life of our residents. Commissioner Bond, you recognize.
I would co-sponsor that with you.
So let's work on a referral to this committee. Mr. Attorney?
Yes, and I remember when we looked at that last year, Commissioner, the concern was, requiring a business to install monitoring equipment in the interior of their premises, and our recommendation to you was, to the body was to start as a pilot program and see businesses that, and we have actually, I can think of at least one, Tom, one business that proffered to participate in a monitoring pilot program. I think that would be my recommendation to start, since we are talking about monitoring equipment.
Yes, but at the very least, switching over to a decibel-based system, which I would like to be part of this referral, because part of the problem is that when we base this off of subjective criteria, which is the audibility at a certain distance, you may have one enforcement officer that may hear it at a certain distance, and another enforcement officer who may not hear it at that same distance. Whereas if we reinstitute a decibel level as the enforcement mechanism, it would provide a more objective measure, regardless of whether the instrument is installed within the facility or not. It could just simply be an instrument that could even be used by the enforcement officer in addition to his or her discretion. With that, seeing no further comment on this item, the item's been moved. It's been seconded.
Who was the second?
It was moved by Commissioner Bod. It was seconded by Commissioner Dominguez.
I moved it.
Oh, Commissioner Dominguez moved
Other way
it.
around.
Commissioner Bod seconded. Mr. Attorney, let's call the roll.
And just to confirm, this is going to be a recommendation for the city commission to refer an LDR amendment to the planning board to mandate progress reports for CUPs at the 6-month mark and yearly, every year while the CUP is in existence.
But I want to make sure that as a result of those progress reports, that the planning board and or staff be able to have the authority to do a modification or revocation hearing as a result of those.
So the yearly report would actually be a yearly modification, revocation hearing?
No, it will be a progress report, but based on what is discussed at that progress report, that the planning board and or staff be able to schedule a modification revocation hearing. If, for example, there's a progress report of an establishment and it's discovered, it's raised there in the report from code enforcement that the establishment
has had 10 noise violations, and they're, having parking violations and sanitation violations, that then either staff or the planning board be authorized to convene a modification of revocation hearing for that specific CUP.
Yeah, that's actually already in the code. Whenever there's a progress report, the board has the authority to schedule a modification revocation hearing. It just has to be noticed for the next meeting.
All right, well, let's include it in the item, please.
Okay.
Yes.
Yeah, and I think part of the concern is that the progress reports are triggered by violations, and this relieves the residents of the violations, because progress reports will happen no matter what.
Exactly. And that's the issue, that in the past, progress, and thank you so much, Madam Vice Chair. It is so good to have someone that has the wisdom of the planning board, because you're so right. It is violations that trigger right now the mechanism to have a progress report before the planning board. The whole idea here is whether you have a violation or not. You need to know that you're going to come before the planning board as the deterrent to prevent the establishments from engaging in activities that affect later on the quality of life of the residents. And we have to be very responsible how we ultimately use this, because we want to make sure that the businesses don't fear opening up in our city. They need to see, okay, if they perform well, it's just a routine thing, it's nothing serious. But if they're causing issues, it could open further review for them. Okay. Mr. Attorney, let's call the roll on this.
Okay, Commissioner Dominguez,
Yes.
Vice Chair Bott,
Yes.
and Chairman Fernandez.
Yes.
The
And
motion
then
carries.
separately, I'll work with Nick on language for your referral to the Land Use Committee regarding the noise meters, decibel levels, and working with code officers.
Yeah, decibel system, reinstituting decibel system, and the noise meters.
And I'll second that.
Okay.
Thank you. All right, let's go ahead and call our last item, number 13. Mr. Director, let's read that into the record.
Okay, item number 13 is to review the city's current maximum development capacity for water, sewer, electrical, and other utilities and public facilities, and how to better use updated modeling and data for projected future demand to inform cities' planning and legislative efforts relating to development.
Okay, is there a motion to bring the item properly before the body?
I'll move it.
The item's been moved by the vice chair, seconded by the chair. Madam Vice Chair, you are a co-sponsor with Mayor Minor on this item. Would you like to present the item?
Just pretend I'm Mayor Minor for a quick second.
I see the similarities.
Yeah. Hello. Big smile. So, yes, so I'm not going to do it justice the way that the mayor would, but this is something that is very near and dear to my heart as well. When applicants come before us, they are required to do studies of, traffic impact and sewer impact and all kinds of different impact, but it doesn't seem like this is happening on a holistic basis. And it seems like, parts of the left hand doesn't know what the right hand is doing sometimes, and we are a city, as I've mentioned earlier in this meeting, that is at the brink of capacity in a lot of ways. And this is an effort to get a better understanding of what we can actually do, what we can actually sustain in terms of development from every possible aspect, traffic, sewer lines, water lines, gas lines, whether or not, gas lines isn't something we think about a lot because it's a private company, but all of this stuff needs to be thought about together holistically, not just for the block and the immediate surroundings of your particular application, but how does it affect the neighborhood? I mean, going back to Town Center in North Beach, which is a perfect example of this, we have 13 buildings going up in an 8x6 square block radius. The first one is almost completed. It's 22 stories. We've got a second one that's going to be right next to it that's 20 stories. We are already pretty full up. And so even if you just look at the traffic impact for that neighborhood, which is already pretty unpleasant for anybody trying to get through that nexus point, we need to be looking at what do all these new residents or visitors or businesses do, not just to those immediate blocks, but to the adjacent infrastructure, connectors and pipes and throughways. And so this would be an attempt to really have a much more holistic view of that analysis, whether it's potable water, sanitary sewer lines, solid waste, stormwater, recreation, open space, mobility issues, public schools, all of it, so that we can make better informed decisions. And again, this is in an attempt not to disincentivize development, but make sure that we develop what we want and what we need and then what we can handle to build the city that we want to live in, not what currently is permitted to be built. Because as everyone has heard me say a bunch of times before, we need to think about what we want going forward, not what we are forced to live with currently.
Thank you, Madam Vice Chair, and certainly I think we need to be looking at, you know, our water sewer systems, you know, our infrastructure, our capacity as we grow. Mr. Director, any comments to place on the record on this item?
Yeah, I would just add very briefly, Mr. Chair, that this is a very, very broad topic. There's, as you can see in some of the initial information that we've included in the memo from the comprehensive plan, there's a lot of information associated with our development capacity. And what we would like to do is, for purposes of policy direction, have this discussion initially. And we've recommended that the matter be continued so that we can coordinate with the Public Works, the Transportation, and the Parks Department, so that we can do a deeper dive into all of these infrastructure capacity issues. We had initially recommended that the item be continued to the March 19th meeting, but given our current print deadlines and in order for us to have more substantive meetings with these different departments and better coordinate, I would suggest we continue this to the May meeting.
Okay.
We meet May 1st.
Is there any, as you work on this, is there any feedback that you would like from the committee at this juncture?
No, I think that pretty much based upon what Commissioner Bott has described and based upon the content of the referral memo, I think we can put together some good data. And then perhaps at the next meeting, when we do a deeper dive into that, we may begin to formulate more policy direction.
Thank you, Mr. Director. With that, is there a motion to continue this item to the April meeting?
I'll make that motion.
I'll second that motion. I think we can adopt it by acclamation, Mr. Attorney. Is that correct?
Yes.
All right, so the item is continued to the April meeting. Colleagues, that concludes our agenda for today. Items 14 through 21 will be scheduled for a future meeting. I encourage you, if you do have priority items, to let the planning director know so that we can prioritize them on our agenda. On March 5th, we will have a special meeting of the Land Use Committee to discuss the hotel-related items that have been previously referred by a number of city commissioners. So we'll be having that meeting on March 5th. Yes, Commissioner. Oh. Let's see. Commissioner Dominguez. Commissioner Dominguez is checking in.
It's 4 o'clock on the 5th.
4 o'clock on March 5th.
Tuesday.
But in any case, if there's any conflicts, please contact the Mr. Mooney's office. And lastly, I just want to thank our staff, our planning director and his office, as well as the attorney's office for their collaboration in scheduling this meeting. I know it's late to do it at 4 p.m., but I wanted to make it a point to have these meetings late in the afternoon to facilitate the participation of the public and our residents wishing to participate in these meetings. So I want to thank our staff for being available after 5 p.m. for the benefit of our residents. With that,
Here.
any other remaining business for the good of the order? No? With that, we stand adjourned.